It's late. All right. So I'd like to call to order, please, the November meeting of the Federated City Employees Retirement System and Federated City Employees Healthcare Trust. Have all trustees present. Under orders of the day, actually, I need to do orders of the day after this, right? Okay.
Yes.
There's a ceremonial item. Someone needs to talk.
We'll do that, Mr. Chair. I don't know, for those of you that don't know, today is Chair Matt Lodge last meeting. If you see him a little sad, that's why. That's the reason why. He's been a member of this trustee of this board for 12 years. The last 10 of which he's been the chair, and he's going to leave a big hole, and it's going to be a challenge to replace him, and he's going to be missed. And so we wanted to make sure that we send him off with a commendation, which I'm going to read for you, and then I will invite anyone that wants to make any comments to do so. Whereas Matt Lodge was appointed to the Board of Administration of the City of San Jose Federated City Employees Retirement System in November 2007 as an employee member. And whereas in appreciation of Matt's 12 years of service, the past 10 years of which were chairman of the Board of Administration of the City of San Jose Federated City Employees Retirement System, and whereas Matt paved the way as the chairman on the following ad hoc committees: disability, governance, personnel, Cortex response, Measure G implementation, and others. Whereas Matt served as chairman of policy from 2011 to 2013, investment committee 2008, governance committee 2013 to 14, and vice chair of the joint personnel committee from 2016 to 2019. And whereas Matt served on the investment committee for 8 years, helping guide investment strategy, updating the investment policy statement to reflect improved governance standards and maintain the fiscal soundness of the system. And whereas Matt has offered stability and a progressive view during a period of composition change of the board, administrative staff, and the economy, and has offered his leadership and guidance on numerous issues throughout his tenure, including but not limited to the implementation of Measure B, Measure G, Measure F, and in the approval of the pensionable pay correction. Now, therefore, be it resolved by the Board of Administration, Federated City Employees Retirement System of the City of San Jose, that the Board of Administration extends its thanks to Matt Lodge for his dedicated years of service to the Federated City Employees Retirement System and for his adherence of high standards of quality, ethics, and integrity for this board and for his performance of value service. Presented this 21st day of November 2019 by the following, which is the full board chair, and to be signed by the current vice chair, Mr. J. Castellano, and myself as the board secretary. Matt? This is for you. And I just want you to know that because you have been with the board for 12 years, we have a surprise for you at lunch. We actually requested 12 chocolate chip cookies for you to take home with you for every year on your board.
Okay. Now that's over.
Not over. I took some notes. I'm going to read off my notes, Matt, not because these are not sincere words, but just because I don't want to forget them. But I do also want to congratulate Matt for 12 very successful years on the Federated Board. When I talk to Roberto offline, I continuously get the impression that Matt, I've only been here for a year and a half now, but I continuously get the impression from Roberto that Matt has been an absolutely solid foundation for other board members as well as the board and the plan itself through all the ballot measures and through the mortgage crisis years. My impression is that Matt has earned a reputation for intelligence and professionalism, integrity, and public trust. And I can imagine that for at least the next chair on the Federated Board, if not chairs after that, will be constantly haunted by the words, "when Matt was here," et cetera, et cetera. So Matt, I want to congratulate you again on your many years of service, and thank you for your stewardship over the Federated plan and over the benefits that the plan provides to all of the stakeholders and the members and the beneficiaries. Thank you very much.
Yeah, I just wanted to add one more thing personal to you, Matt. Two things. Number one, I just want to thank you publicly for your support on all these years since I joined the Office of Retirement Services in 2013. You know, we had not always agreed, but I have always known that you have my back and you have my support. So I appreciate that. And also, and secondly, your straightforward way of doing business. Again, we may not always agree, but I have always been clear on what your thoughts and directions are, and that made my job a lot easier. So for those two things, I just personally wanted to thank you and wish you the best of you, the best of luck in the future, and remind you that these are public meetings, so you're certainly welcome to either watch them or stop by whenever you have the time. Thank you.
I will not, and thank you. Appreciate it. I'll just make a few comments because I'll get us back on track and on time. I am very humbled by this opportunity as a point of service. What's interesting is I actually stopped counting the retirements at 1,000 myself, and I asked Barbara to get me some information. We've had over 2,000 lives come through here, either as retirees or deferred vested since I've been on the board. It's a lot of humans and people that we need to care for, that we're working on behalf of. We've had almost 1,200 people pass away since my time here, so members and their beneficiaries that we need to care for, and we're serving. And that's really been my point of how I've done all this. What's funny is I've got to serve with 25 other trustees. It's kind of that number sort of shocked the heck out of me. And that there's only 5 employees in retirement services that were there when I started and who are there now. This has been a very interesting 12 years. It's not been easy. I won't kid any of that. But there's just been some monumental changes and things that we're doing on behalf of our members that I think is respectable, and you should be proud of the service that you're giving and focus on the names of the people that come through here, because those are the people we're serving. It's not, if you're in this for an ego thing, you're in the wrong place. And so I'm humbled that I'm glad to get this over with so we can go on to the actual orders of business. But this is, it's been a pleasure to serve, and I'm actually glad to turn the page. So thank you. Yeah, thanks. Okay, so under orders of the day, so there's a line item on there for a closed session. That closed session will actually occur at the end of our meeting, not at the, we will adjourn after that, but we will hold the closed session item at the end of the orders of the committee reports and everything else, so we're not going to go to closed session now. So under orders of the day, I have a few items to read. So that closed session will not be heard until the end. So we're not going to do it right after the the time certain ones. Let's do it later. We have 2 time certain, one at 8:45, item 1.1A, Albert Mataroli, electrician, Public Works Department, application for service-connected disability retirement, effective July 13th, 2012, 5.9 years of service. And then we have a 9:30 time certain for Rosanna Prezzuti as well. I can read that whole detail there. We have a withdrawal of service retirement application by applicant of item 2.1B, Cheng Tung Cheng, senior engineer, planning, building, and code enforcement, effective November 2016. He is withdrawing his application for retirement. And we have no items to waive for sunshine. So under orders of the day, I'm just moving the closed session item to the end. We have our 2 time certains of note, and we're withdrawing, I was going to call him John, but the name I know him, Cheng Tung Cheng's application. Do I have a motion on the orders of the day?
Motion to approve the orders of the day.
Is there a second? Seconded. Great. Of course, early. So I'm going to go to the consent calendar instead of our time certain. We have item 2. We have any of the items need to get pulled for considerations. This is item 2.1 through items 2.6. Does anything need to get pulled for consideration?
Motion to approve the consent calendar.
Is there a second?
Second.
All those in favor? Aye. Opposed? Okay. On to item 3. I'd like to request a moment of silence for those who have served the city and have passed. Thank you. Okay. The clock seems to not want to change. So what I'm going to do is I'm going to kick off the beginnings of item 1.1A, the time certain for 8:45, and that way by the time 8:45 kicks around, we'll get going. So, okay, so this is the, let's make sure I get my script. So this is the application for service-connected disability retirement for Albert Mataroli. Mr. Mataroli and Mr. Horner, will you please come to the front table? Please come to the microphone, and will you be presenting any witnesses other than yourself?
No, we will not.
Thank you. So, Mr. Horner and Mr. Mataroli, correct?
Yes.
Did I get the name pronounced correctly?
Yeah.
Okay, thank you. I'd like to, so I'll be reading through my script here as per typical, and I would like to introduce Catherine Schaefer, who will present the summary of the application, and Dr. Tierman, who will present the results of her review for the medical records and the medical examination of the applicant. Schaefer?
All right, the applicant's name is Albert Mataroli. Classification is electrician, Public Works Department. Attorney, Stephen Horner. Age 47. This is a service-connected disability for number 1 back. Years of service, 5.59. Date service retirement application received is non-applicable. Date disability application received is April 21st of 2014. Current work status, Mr. Mataroli separated on July 13th of 2012. Status at time of separation was a leave of absence. Status at time of application was separated, deferred, vested. Department accommodations, the board medical advisor's restrictions could not have been accommodated in Mr. Mataroli's own position. The restrictions could have been accommodated in a different position. Was disability application delayed greater than 4 months? The answer is yes. Occupational injury dates, March 1st of 1999 and December 3rd of 2008. Permanency, MMI, the answer is yes. Work restrictions, service-connected disability restrictions. 1, able to sit and stand at will. 2, no repetitive bending, stooping, or twisting. 3, no lifting greater than 25 pounds. 4, no pushing or pulling greater than 30 pounds. 5, no crawling or crouching. 6, no climbing ladders. Non-service connected disability restriction. 1, unable to use narcotic medication at work. Disagreement among physicians. 2015 San Jose Medical Director's drafted report concludes that there is no impairment. 2018 Medical Advisor's review added a consideration of the impairment of a new 2008 disc herniation in support of impairment. Board Medical Advisor also provided list of work restrictions.
After I go through this? Okay. Thank you. Dr. Chairman?
Good morning. I just want to clarify one of the points that Catherine stated. The original report was written by Dr. Das when he was medical director here. The reason he said initially that there was no impairment is Mr. Mataroli did come to the city of San Jose with a previous history of a disc herniation and surgery. However, he did pass the San Jose physical and was able to work without pain for over 2.5 years within the position that he had. For this reason, I felt there was impairment because he had a brand-new injury with changes on MRI that was consistent with a recurrent disc herniation. So I just want to clarify that point for you. He continues to have pain. It is not good to keep operating on backs. They get worse and worse and worse. And for that reason, this is why we have the work restrictions. All of the evaluating physicians concur that he has work restrictions. And the question was, which I felt, is that, yes, he did have impairment, he was able to do the duties of the job, he had a new discrete injury, and there was an MRI that showed an increase in the DIS level.
Okay. Mr. Mattaroli or Mr. Horner, will you please confirm that you received the staff letter dated November 7th, 2019, notifying you of this board meeting?
Yes, we confirm.
Will you stipulate to the relevance of the reports to the disability retirement application?
As to the relevance, yes.
Thank you. Do you wish to introduce additional medical record reports or other documentary evidence for the board's consideration?
Not at this time.
Okay. Please identify all witnesses who will testify on your behalf.
Mr. Mattaroli.
Thank you. I would like to introduce Mr. Russ Requeta, Disability Counsel, to summarize the committee's position, basis for the position, and evidence in records supporting the position. His memo is included in the disability packet. Mr. Requeta.
Hi. As you might know, this has proved to be a somewhat difficult case for the committee. The committee was unable to come to a recommendation on the ultimate issue. As you know, there is in any application 3 issues. First is the applicant incapacitated from the performance of duties. With respect to that issue, the committee did conclude that Mr. Mattaroli was incapacitated as of the relevant date in July 2012. So that's the recommendation on that issue from the committee to the board. Then the second issue, as in every application, is service connection. And as to that, the committee agreed that the evidence establishes that Mr. Mattaroli's employment with the city of San Jose aggravated in a real and measurable degree the prior condition he had with respect to his back. So the committee recommends that the board conclude that Mr. Mattaroli's incapacity is service-connected. Well, that leaves the third issue. And the third issue, as is the case with all the applications that come before you, involves the interactive process. The committee, and as the board knows, that is the city's process by which it determines whether other positions in the city can accommodate the work restrictions that are relevant to the applicant. In this case, Mr. Mattaroli did not participate in the interactive process. And the absence of participation raised 2 troubling questions of the committee that resulted in the committee not able to come to a recommendation. And the committee would instead like to surface these questions to the board for the board's consideration of them, and if the board determines that it's appropriate, to refer those questions to the board's general counsel. The first question that troubled the committee is that Mr. Mattaroli was terminated for cause in July 2012. In other words, his ceasing employment with the city was not necessarily due to his disability, but instead due to the termination for cause. So the issue for the committee that troubled the committee and perhaps might trouble the board is whether that circumstance, termination for cause, forfeits Mr. Mattaroli's ability to receive a service-connected disability. So that's issue number 1. The second issue that is related but is distinct that the committee found troubling and would like to receive or would like to or recommends that the board consider this issue, and the results of the board's consideration will be helpful to the committee in future applications, is the fact that, in a sense, putting aside the termination for cause issue that I just referenced, and just instead focusing on Mr. Mattaroli's failure to participate in the interactive process, whether in this situation where, as you heard from Ms. Schaefer, that Mr. Mattaroli, even if he had participated in the interactive process, was incapacitated from serving or coming back and performing the duties of an electrician, but according to the return to work coordinator, would have been eligible to be placed in more sedentary job positions that could accommodate the work restrictions set forth by Dr. Tierman. Whether in that situation, his failure to participate in the interactive process should result in a denial of the application. And Mr. Horner, Mr. Mattaroli's attorney, has raised before the committee the sort of embedded issue that requires an interpretation of the relevant language in the San Jose Municipal Code, which I will just summarize in hopefully a more or less accurate way. It's always better to actually look at the language, but I don't think that's necessarily germane for presentation here, that in the definition of disability, the question is whether the applicant, under the Muni Code language, is incapacitated from the performance of the position of the job class the individual is in, or other positions in the classification of positions. So that's the magic language. That's the language in the municipal code. And in this case, the committee concluded that Mr. Mattaroli cannot perform the duties of electrician. So the other issue for you that troubled the committee is whether the fact that there were other sedentary non-electrician positions that were vacant, but that Mr. Mattaroli was not eligible for because he'd been terminated and therefore didn't participate in the interactive process, whether that fact situation renders a denial of his application appropriate. And I hope I've been clearer than I think I've been on the second issue.
Okay. Dr. Chairman, do you have anything to add to your written report to the board's, for the board's consideration?
No, I don't.
Is there a member of, is there a representative from the Public Works Department who wishes to add anything to the department memo dated May 9, 2014 on the application's work status at the time of his retirement, or wishes to present any other testimony relevant to the issues to be determined in this hearing? Not seeing any. Is the return to work coordinator present and wishes to add anything to their memo dated January 9th, 2019 on accommodation of work restrictions, or wish to present any other testimony relevant to the issues to be determined in this hearing?
Elsa Cordova, return to work coordinator with the city of San Jose. I don't have anything to add to our memo, but I would say that the city's position with regards to the municipal code language is different than what has been presented by Mr. Mattaroli's counsel, and we believe that the ability to place an employee in a different position as a form of accommodation does not in fact entitle the employee to a disability retirement. That is the process that we go through. In fact, the class is defined, what a class is defined in the municipal code and refers to the classification plan and the pay plan. So therefore, we believe that placing Mr. Mattaroli, had he gone through the interactive process in another position, would have been the appropriate avenue to have gone through as per the normal return to work process.
Okay, thank you. Mr. Mattaroli or Mr. Horner, please present your testimony in support of the application.
Well, there's been a lot of evidence presented, so I think our presentation can be fairly brief. And first, I'd like to respond to the statements that were just made. Up until Mr. Mattaroli's termination, he was on total disability. So he was interacting with the city, but each time, the response was, I have been placed on total disability, I can't perform any job functions. I would also like to address this disagreement about the classification question, and this has been addressed by the 6th District Court of Appeal as to this board and this Muni Code. So I don't think we really need to go around and around. And that is the Myers case. And I'll just read from it. It says, in determining whether a member has a disability within the meaning of the municipal code, the board necessarily must determine as a matter of fact, whether the member could perform the duties and functions of any other position in the same classification to which the city may offer to transfer him. End quote. And the case goes on to say this is not a theoretical exercise. It is any position that the city could and would offer him at the time. So for this return to work memo to say there was probably other classifications out there, it's just simply, it's not good enough. And it's been addressed and found to be an error by the 6th District related to this exact process. It's pretty rare in law to have a precedent that is so directly on point as this case is. Just to briefly add to what Dr. Tierman said, it was a new injury. There was a herniation of the same L5S1 disc. There's also a second herniation that occurred as a result of the injuries while he was working for the city. So I do agree that it's service-connected, but I just wanted to add that. Now, as to the termination for cause, this board needs.
I'm sorry, could you lean closer to the
Oh, I'm
microphone
sorry.
instead of farther away?
Yeah, no problem. As to the termination for cause, this board needs to keep in mind that we're dealing with a vested benefit here, and it cannot be extinguished simply by a termination. And that's supported by the relevant sections of the Muni Code, all of them, that refer to separation from service. That nowhere does it qualify separation any more than simply saying separation. It doesn't say anything about whether the termination was because leave ran out or whether the termination was for cause. And the reason is that we're dealing with a vested retirement benefit here. And we're happy to present further evidence. I believe it is in the record and it's been discussed at the committee, been summarized by Mr. Rashada. So at this point, we'd be happy to answer questions.
Okay. Do you have any questions that you'd like, do you like to question any of the witnesses that have testified?
No, sir.
Okay. Dr. Tierman, do you or other witnesses who have testified have any rebuttal to the testimony provided by the applicant?
No, I don't.
Okay. Would any of the board members like to ask questions of any of the witnesses who have testified? Okay. Mr. Lederman, did you want to say something, Mr. Recato?
Just a comment.
Okay.
With all due respect to Mr. Horner and his assertion as to the meaning of the Myers decision, appellate court decision that was issued in favor of the applicant and against this board, I would say that the portion that he quoted is what we lawyers call dictum. In other words, it was not a necessary element in the reasoning of the court to come to its conclusion, and in fact did not address the kind of issue that this application raises and that Ms. Cordova addressed, where, for example, you cannot do job A, but you can do job B, or at least the burden, or at least the applicant has not met the burden of persuasion of showing that the applicant cannot do B. So it's A versus B. That kind of sharp factual conflict was not an element in the Myers case and is an element today. This is not to say that the committee has an opinion one way or the other. Instead, the committee is merely troubled by this issue and is bringing it to the board for its consideration.
Mr. Horner, you're welcome to rebut if you'd like.
We continue to disagree. The Myers case absolutely stands for the proposition that one, it has to be in the same classification, and two, it is not a theoretical examination. There needs to be a position that could have and would have been offered to the applicant.
Okay. Question?
Not being familiar with the classification system, is the city saying that the rehire process would necessarily result in a new position in a different classification? Or as a result of the interactive process, would it be possible that there would be a position in the same classification that didn't require the physical duties that the previous position required? made myself clear?
I'm happy to respond if that was directed to me.
Actually, it was mostly directed towards the city.
Okay.
Ms. Cordova, would you please come forward? And you're welcome to sit if you'd prefer, if it's easier. Just make sure the microphones are on.
Yep, it looks like it's on. Is this on? Okay. Through the interactive process, if an employee has restrictions that preclude them from performing the essential functions of their current classification, then we will look to other classifications that the city has vacancies for to see if they can perform those classifications, the functions of those classifications with or without accommodation. So if somebody presents with disability restrictions, we first look to see if they can be accommodated in their current class. But if they can't, then we look to see what other vacancies are available that can accommodate the restrictions that the employee has. Here, Mr. Mattaroli was not able to even go through that process because he was separated for cause.
So to further that question, does the city hold any discussion for return for work with Mr. Mattaroli at all?
Not according to our records. Again, he was separated for cause. He did not go through the interactive process.
So is it correct to say the city in this, as of today, is not able and willing to offer another position for Mr. Mattaroli?
Well, today, we would not be, he's separated, we would not be offering him another position. At the time of his employment, had we gone through the interactive process, we would have pulled that vacancy list and determined whether or not he could have been accommodated. There are many sedentary positions within the city that could have accommodated the types of restrictions that Mr. Mattaroli had at the time prior to his separation.
But bear in mind, he was terminated for cause. And then
Correct.
how does that play into return to work discussion?
Essentially, the interactive process is not able to be completed because he is no longer an employee with the city, and we don't interact with employees who are no longer active.
And just to clarify, the termination for cause occurred prior to his re-injury on the job? No. Afterwards,
I'm sorry, it occurred before.
before
Before termination from the job.
the
Sorry.
re-injury.
The re-injury, I'm sorry if I
The
wasn't clear.
re-injury
Yeah.
was in December 2008. The termination was in July 2012, so several years later. We did not go into, at the committee level, we did not go into the underlying events that led to the termination for cause, so we do not know the dates of whatever incidents formed the basis for the termination for cause. Odds are, those events occurred after his re-injury in December 2008, but that is merely a supposition on my part.
So does that mean he had a re-injury, continued to work, and during that continuing period, working with the injury, something occurred that caused termination with cause?
And certainly you could
Occurred.
ask. Mr.
He was on
Mazzarelli.
leave at the time that he was terminated for cause, from an injury.
I see.
So he was unable to work in any capacity at the time that he was injured. And this is why we don't have this interactive process, because he was completely out at that time.
From the point of re-injury, he was on leave until the point he was terminated?
Not the entire time. There was a period of time after '08 that he worked. He had been on leave for roughly a year at the time that the termination was issued.
I went out on December of 2011 for a couple months. I could barely walk. Everyone could see how badly injured I was.
And then if I can talk a little bit about the classification. The Muni Code definitely says classification. That's in there, and that was discussed in the case that I referenced. But just to kind of put a little bit of context to it, Mr. Mattaroli is an electrician. He's a trained electrician. He's a union electrician, and he could not work any electrician jobs. What the return to work coordinator is presenting to us is that in every job in the city, maybe there was one he could have done. And that's that's an issue, and that's outside of what should be done in this setting.
And again, I'm still a little unclear. So working in the same classification means working as an electrician and only an electrician. Is that what you're
Not
saying?
from the city's perspective,
I'm sorry?
not from the city's position.
Not from the city. So there are other jobs in the same classification that are non-electrician jobs.
When we're referring to the same classification or the classification of offices or positions, we interpret that to be the city's pay plan, which includes all of the classifications that the city has here at the city. So we have a very different interpretation of that meaning.
And I'm not disagreeing with that. My point is that it's been said that he cannot work any jobs in his classification. And I'm just trying to illustrate that he has a very specific job, and you're asking him to go way outside of that theoretically to find some other job in the city, which was never even discussed.
Other questions about the testimony that's been presented from the board?
I'd like just some clarification if it's available, which is, before termination, and with the conclusion that, or at least that state where he was on total disability, was there no opportunity or communication of any kind to be able to engage in this interactive process? Or maybe, did it exist at that period?
Well, he was on leave for large periods of time. When he was on leave, he's interacting with the city. I don't know if we're labeling that an interactive process or not, but, you know, he comes back with restrictions and says, I can't work for X period of time. I'll check back in with you. He did come back to work and worked a modified duty for a period of time, and that's when one of the injuries actually occurred. The car accident actually occurred while he was on a modified duty within his job description. So these things were happening as the relationship progressed, but the official return to work coordinator wasn't involved, as far as we can tell, until after the termination.
So there wasn't really official interactive process that kicked off. It never came up and it never occurred, correct? Thank you.
Can I just interject one point, is that if you're not permanent and stationary, if the doctor has not said, this is the best he's going to be, the interactive process really doesn't start because he's on modified duty temporarily, not permanently, even though the likelihood, I totally agree, would be permanent. So it's not unusual for that to happen. You would not engage in, if you're on temporary total disability versus permanent disability.
And the permanent disability assessment and conclusion would be triggered by the final doctor's report?
By the
I think I hear
final
you saying?
doctor's report, there's a whole legal under workers' compensation, how that's done, because they won't know what position they can put him in, because he might get better or he might get worse. So they want that permanent.
Thank you.
Dr. Chairman, did we ever get to permanent stationary?
You know, I have to say, I am not sure, and I'd have to go back to my records.
He's in a permanent stationary.
Yeah, I have that he's MMI.
Excuse,
We have that he is MMI.
When was that done?
I don't, the executive summary doesn't give me a date. It just says yes in the box.
I don't know.
So he was classified as being,
it was in 2014.
thank you.
More questions from the board? I'm going to close the hearing for evidence. Mr. Lederman wanted to talk to the board in closed session briefly, and then we'll come back for our deliberations.
We have to go through a process.
Oh, please.
If I may explain, and just for the record, I'm Harvey Lederman with Reed Smith, the fiduciary counsel to the board. Good morning to you.
Morning.
When the agenda was posted, we, for the first time, the board became aware of the request being made from the committee to address two issues in the memorandum from the committee through Mr. Requeta. The two issues that are being requested for the board to determine are interpretations of the law. And I believe it would be important in the context of addressing the facts that fit into the law, that I have the opportunity to brief the board on the law that's applicable to these issues so that you are fully advised as to what your authority is and the scope of those issues that have been presented. Because that came to the board's attention after the agenda was posted and is something that we need to deal with now in addressing the applicant who is before us. The Brown Act, we did not agendize a closed session for that purpose, but the Brown Act allows us to go into closed session on a 2/3 vote of board members present for a matter that arose after the posting of the agenda that the board needs to pay attention and make an immediately address at this meeting. And so, Mr. Chairman, I would respectfully recommend that the board vote, and by a 2/3 vote, I can go into closed session as your fiduciary counsel without the applicant and without staff and staff counsel present to advise you on the law, and then we can resume this matter once you have an understanding of the legal parameters. So that would be my recommendation to the board.
Okay. Is there a motion on that?
So moved?
Is there a second?
Second.
Okay. All those in favor, again, this is to add us to go into closed session to have this discussion before we come back. So all those in favor?
Aye.
Opposed? That's unanimous. We'll be back shortly. From closed session, we have no reportable action out of closed session. We're at the point where we are deliberating the evidence that's been presented from all the parties. Any discussion from the board on these deliberations? Would anyone like to make a motion? Any deliberation?
I make a motion to grant the disability.
Okay. Is there a second?
Second?
Okay. Other comments and questions? All those in favor? Aye.
Aye.
Opposed? Seeing none. Thank you for your service and thank you for your time today.
Thank you.
Okay. A little bit past my time, certain of 9:30. Thank you for your patience. I'd like to move on to item 1.1B. This is the service connect, so Rosanna Pizzuti. This is a potential cancellation of a service-connected disability retirement allowance pursuant to Municipal Code Sections 3.28.1370 -3.28.1390. Welcome back, Ms. Pizzuti. Ms. McBride. So again, I'll read my usual script as you get settled, and so we'll go forward from there. Rosanna Pizzuti is retired from service for a service-connected disability. At this hearing, the board will determine whether Ms. Pizzuti is still incapacitated for the performance of duty pursuant to Municipal Code Section 3.28.1370A. Will Ms. Pizzuti or her attorney, Mr. McBride, you've already come to the microphone, will you be presenting any witnesses other than yourself?
We will not.
Thank you. So again, I'll go through my script. I would like to introduce Catherine Schaefer, who will summarize the terms of Ms. Pizzuti's service-connected disability retirement, and Dr. Tierman, who will present the results of her review of medical records and medical examination of the applicant. Ms. Schaefer.
Okay, this executive summary is a reevaluation. The applicant's name is Pizzuti Rosanna. The classification is Police Safety Radio Dispatcher of the San Jose Police Department. Attorney is John McBride. Age at retirement, which was September 26 of 2013, was 38. She was granted a duty disability retirement effective 9/26/13 and was granted by the Santa Clara Superior Court on 3/17/16. It was adopted by the federal board at the April board meeting on April 21st of 2016. Years of service is 12.97. The history of filings. Ms. Pizzuti applied for a disability retirement. Her date of separation was September 25th, 2013. At the board meeting held on February 19th of 2015, the Federated Board heard her case and voted to deny the application. After an appeal, Superior Court granted a non-service connected disability on December 17th, 2015, for a benefit effective 9/26/13. Subsequently, on March 17, 2016, Santa Clara Superior Court granted a service-connected disability effective 9/26/13. The reason for the reevaluation: video evidence and updated medical reports were provided to the Office of Retirement Services in August 2018. Video evidence shows Ms. Pizzuti performing tasks with her upper extremities. Current work status is retired. Status at time of separation was a leave of absence. The return to work coordinator accommodation of restrictions. An updated memo was received May 8th, 2019 from the return to work coordinator, which states that the board medical advisor's restrictions could have been accommodated in Ms. Pizzuti's regular position as a public safety radio dispatcher. Body parts discussed in the medical reports are left upper extremities. The occupational injury dates was 1999 through 2011. Permanency, MMI, the answer is yes. Work restrictions are no lifting greater than 20 pounds on an occasional basis, less than 25% of the time. Able to push and pull 12 pounds with left hand occasionally. Able to perform fine manipulative tasks with left hand up to 2/3 of an 8-hour day. Able to perform keyboarding and mousing activities up to 2/3 of an 8-hour day.
Okay. Dr. Chairman?
Mr. Chair, before I start, I just want to know if the board wants me to give a little bit more medical background on this case, or I should just go to the present thing at hand.
I think just because of the case that we have so many new trustees, maybe a brief summary on the background to help make sure we're all looking at the same problem set.
Ms. Pizzuti was a police dispatcher, and she began having problems with both arms, but mainly her left arm. She was initially diagnosed with repetitive strain injury, and further testing showed that she had an ulnar neuropathy. An ulnar neuropathy is like, it's a nerve that goes and innervates your hand. When you hit your funny bone, you know where your ulnar nerve is. She had an EMG, which is a test in nerve conduction velocity to see if there was any problem with the nerve directly, was done, and it showed a mild neuropathy. She was operated on. After the operation, she became worse because her doctor said she had what was called a regional pain syndrome, which is an inappropriate stimulation of a nerve to cause pain. This pain is not caused by overactivity or underactivity. It can happen anytime, etc. So that's basically where she is now. She continues to have pain in her left arm, mainly, and it was the videotapes that people reassessed to determine whether she still has the same disability that she had or purported to have when she retired. There's a few points that I do want to make. Although it was determined by a superior court, which is legal decision, I'm a medical person. A medical opinion is not the same as a legal opinion. Medical opinions are based on the best literature available, the best practices that are done, and research. Now, we change when the research changes. So one opinion, it's not quite the same. It's not a matter of interpretation. It's a matter of what's in the medical literature. Not all physicians keep up with the medical literature, unfortunately. I just want to state that the AMN guidelines to the evaluation of disease and injury causation, AMA is a gold standard for especially determinations of disability found. A myth had been perpetuated from one review to another implicating repetitive strain injury as a cause of ulnar nerve entrapment in elbow for workers. Reviews on repetitive strain injuries cite no credible medical literature to support ulnar nerve entrapment, and there is no credible literature to support a causal relationship. The only prospective high-quality study did not show a causal relation between repetitive strain injury and ulnar entrapment of the elbow. So I just want to start from there. Regardless, Ms. Pizzuti did appear to have a complex regional pain syndrome. And the three things that I just want to mention to that: pain is a subjective complaint, it's very personal, and again, a subjective experience. There's no test that can measure or locate the pain with precision, so the health professional relies on the patient's own description of the type, timing, and location of the pain. Therefore, it is absolutely incumbent on the patient to give an accurate history and assessment of their pain limitations. The physician must weigh three factors when determining: that is, the patient's self-report about changes in pain level upon performance of discrete physical activities, the results of his or her physical examination, and functional capacity assessment data. In this case, there are videos that provide visual of some daily activities that one can observe pain behaviors during those activities, the avoidance of the use of the affected limb, or other signs of chronic pain during activities that are documented. The last point I want to make about complex regional pain syndrome is that even though the patient has pain, it does not damage the arm. In fact, disuse often leads to more pain and disability. Using the painful extremity may hurt, but will ultimately lead to better function. Again, this is not only my opinion, it's the opinion of the AMA guidelines. Ms. Pizzuti has a lot of subjective complaints. Her complaints were up to 10 of pain levels. Up to 10 of pain levels is that you have such severe pain that you're barely conscious. To give a comparison, childbirth is only 8. So we're talking about very, very severe pain. And it could be that Ms. Pizzuti might not have understood exactly what these pain levels mean, but the doctors who are asking those questions should have questioned, are you sure it's a 10? Especially in medical legal situations. I just want to say in closing that the AMA guidelines, again, to the evaluation of work ability and return to work, and the Social Security Administration states that physical or mental impairment must be established by signs, symptoms, and lab findings. If we don't have someone who is reliable about their pain levels, we must look at the more objective findings to determine disability, not to just say there's no pain or discount pain. And that is why the functional capacity evaluation in the videos are so important in the case. And the functional capacity shows the evidence that she does have these tolerances.
Okay, thank you. Mr. McBride, do you want me to address it to you or to Ms. Pizzuti?
You can address it to me.
Okay, Mr. McBride, would you please confirm that you received the staff letter dated November 7th, 2019, notifying you of this board meeting?
We did.
Will you stipulate to the relevance of the reports provided to the board in connection with this hearing today?
We do.
Do you wish to introduce additional medical reports or other documentary evidence for the board's consideration?
We do not.
Please identify all witnesses who will be testifying on your behalf.
And we will have no witnesses.
Thank you. Mr. Requeda, Disability Council, please summarize the committee's position, basis for the position, and evidence in records supporting the position. His memo is included in the disability packet.
As the board knows, there's only one issue before it today, and that is whether or not Ms. Pizzuti now is incapacitated from the performance of the duties of police dispatcher or other related positions. I'd like to read to the committee a stipulation that I and Ms. Pizzuti's attorney have entered into, which I think simplifies today's consideration. The parties stipulate that Rosanna Pizzuti is disabled from assuming the responsibilities and performing the duties and functions of the position of public safety radio dispatcher, position number 8514, as more fully set forth in the San Jose Federated Employee Retirement Plan at section 3.28.12. We're stipulating that she is unable to perform the duties of the position of police dispatcher now. Second, evidence will be provided that Ms. Pizzuti is capable of satisfactorily assuming the responsibilities and performing the duties and functions of the position of police data specialist, and that has a number of 1181. So that's merely a notice to you that evidence will be provided, and in fact, I will offer the testimony of Ms. Veronica Andrade for that proposition. But here's the next important element of the stipulation. Ms. Pizzuti stipulates that she will not contest a finding that she is capable of satisfactorily assuming the responsibilities and performing the duties and functions of the position of police data specialist. So, lawyer words, the bottom line is, we're agreeing that Ms. Pizzuti cannot now perform the duties of her prior position of police dispatcher, and Ms. Pizzuti is agreeing, if I can use that word, that she, or I'm sorry, more accurately, I was incorrect in saying that. Ms. Pizzuti today is not contesting that she is capable of performing the duties of police data specialist. That doesn't mean she's agreeing that she can, but it is saying that she's not going to dispute it. So accordingly, we're going to provide evidence in a very brief compass to the effect that she can perform the duties now of police data specialist. Now, that's an important stipulation because it both eliminates some time that would otherwise be needlessly spent before you today, and focuses, I think, the board on the issue that the committee thinks is the relevant issue for you to determine. One important, the board understands already that it denied her application back in 2015 for a service-connected disability retirement. The board understands that Ms. Pizzuti went to Superior Court and won, and had the Superior Court overturn the board's determination, resulting in the board's granting in 2016 her service-connected disability retirement. Well, thereafter, it came to the board's attention kind of late, really last year, about relevant information that had existed in 2015 but had not come before you. And those were sub rosa videos taken between March and May 2015 of physical activities of Ms. Pizzuti. and in addition, a transcript of a deposition taken of Ms. Pizzuti in a workers' comp proceeding in July 2015. All events occurring in 2015, germane to the period of time when the board was initially considering the application. Now, the committee does not think it's necessary or useful for the board today to view those videos, or even to view the statements by Ms. Pizzuti herself to this board in February 2015, interesting though those statements are. They're not, I think, necessary to the board's consideration of the issues before it today. I merely point out that in the material presented to the board, there are lengthy summaries of these videos and the implications to be drawn from these videos by individuals who I would suggest are more germane to a consideration of them than perhaps we are as lay people. So there's one orthopedic surgeon, his name was Max Moses. He was the agreed medical examiner for workers' comp purposes. He issued a number of reports beginning in 2013 concerning Ms. Pizzuti. So therefore, obtained ever more insight into her condition. Well, after those reports, he was shown, after a number of those reports, he was provided the sub-rosa videos and he viewed them. And in his December 2015 report, he summarized what was in the videos and also concluded there was a marked difference between what Ms. Pizzuti had otherwise told her physicians and himself, had otherwise testified to in her workers' comp depositions, and the facts in the videos. His conclusion of a marked difference, which is certainly understated, which is the language he used. In addition, Dr. Tierman referred, that report was in December 2015. Similarly, Dr. Tierman referred this matter out more recently to another orthopedic surgeon who conducted an independent medical examination. His name is Kenneth Ishizui, and he issued a report this January, and he again itemized the contents of the sub-rosa videos. Again, another professional perspective on what is in those videos. But the inference for the committee from this sort of history is that Ms. Pizzuti was not a reliable historian of her pain levels, of her symptoms, and of her limitations in 2015. And therefore, and this is an inference, but I think it's an inference that's a reasonable one, and therefore, Ms. Pizzuti cannot be considered a reliable historian of her pain levels, limitations, and symptoms now in 2019. So that was an important first step for the committee, but that's really only a step. The next real issue, however, is what are her work restrictions today? And Dr. Tierman, in her reports, based on the functional capacity evaluation, as she mentioned, and other more objective manifestations of Ms. Pizzuti's current medical conditions, and not relying on her subjective representations of her pain levels, did conclude that she had significant work restrictions. And it is due to the existence of those work restrictions that we decided that it was necessary to enter into a stipulation to the effect, the stipulation I just read to you, that Ms. Pizzuti is not now able to perform the duties of police dispatcher. We think that the committee considers that to be a correct inference from the information, from the medical evidence before it. So there remains the issue of police data specialist. Now, Mr. McBride at the committee level, and I presume today, has made the same kind of argument that was made in the last hearing this morning that you heard. In other words, to rephrase it in this context, that under the relevant provision for reevaluation, section 3.28.1380, assuming I'm citing that correctly, that Mr. McBride says, police data specialist, even though I know this is more appropriate to come from Mr. McBride, is not in the same classification of positions as police dispatcher. And we, at least the committee, is looking for direction from the board on that issue, but thinks that it would be reasonable to say the police data specialist is sufficiently related to the duties and the classification of police dispatcher to make them to make that an appropriate position for purposes of 3.28.1380. But and the committee also looked at the other medical evidence, most of which is by a pain management specialist. Peter Abacha is the name of the physician, and for the reasons outlined in the memo to the board, concluded that his testimony and reports were based on a very weak, insubstantial foundation, mainly the subjective reports from Ms. Pizzuti, who we believe the evidence confirms is not a reliable historian, and therefore his reports and his conclusions are insubstantial evidence and are outweighed by the other evidence in the file and the conclusions and reasoning set forth in Dr. Tierman's report. So that is the situation. The committee is opposed to the is in favor of a conclusion or recommends to the board that it find Ms. Pizzuti as of the current time not to be incapacitated, and that the police data specialist position be a position that is one that she's physically capable of performing. And we do request that the board consider the testimony that we would like to offer by Ms. Veronica Andrade to the effect that Ms. Pizzuti is physically, that the work restrictions set forth by Dr. Tierman are able to be accommodated in the position of police data specialist.
Thank you. Mr. Lieberman, did you want to make a comment? Before I keep going?
If I may, Harvey Lederman, Fiduciary Counsel. On behalf of the board, I'd like to ask two questions of both counsel, because you're both apparently have reached a stipulation, although I will tell the board that from the board standpoint, you're not bound by any such stipulation, but I'd like to ask two factual questions here. And the first one is, given the applicant's current work restrictions that Dr. Tierman has found and are identified in Mr. Riqueda's letter, can the applicant be reinstated to the dispatcher position or another position in the same classification as dispatcher?
The position, my position on that is that she would, Mrs. Pizzuti would not be physically able to be, currently, at the present time, perform the duties of the police dispatcher position or the other, I think there's one or two, whatever the listing in that precise classification series, that she would not be physically able to perform the duties.
And her work restrictions could not be accommodated in that position?
Yes.
Okay, and the second
Did you want to ask
question.
Mr. McBride that as well? Okay,
Is that
I
true,
don't
Mr.
disagree with
McBride?
that. I think the evidence in Dr. Moses', one of his reports, he describes the position we're talking about and what it entails. And it is very, very active And there is no situation where somebody can raise their hand and say, I want 15 minutes off. It's constant. And so I don't think there's any way that she or anybody with her conditions or limitations could perform the functions of radio dispatcher.
And the city can't accommodate her
No,
work
there's no
restrictions.
accommodation in that
Okay.
particular position.
So my second question on behalf of the board is the police data specialist position in the same classification as dispatcher?
Clearly, it is not. If you simply read the description and look at the classifications, that was in the original trial.
Does
We
the
had
co-
the classifications, and it's clearly not in the same classification. As a matter of fact, notwithstanding what Mr. Requeta said, those positions are not sufficiently related. I mean, one is totally different than a clerk in the office.
Does the committee have a position as to whether those positions are in the same classification?
The committee does not.
You don't have a position?
No.
Oh,
The committee,
we don't know?
the committee did not, and perhaps mistakenly so, but did not consider that issue to be one within their province. It required an interpretation of the municipal code, which the committee perhaps mistakenly thought was one for the board and its general counsel, and perhaps further mistakenly concluded that the board and its general counsel would not necessarily be interested in the opinings of the committee on this issue. So based on those assumptions, perhaps mistaken ones, the committee punted on that issue.
Mr. Chairman, I think it would be appropriate to ask the city's representative here today whether the city believes these two positions are in the same job classification.
The return to work coordinator was the next person I was going to ask up, so we could ask, I'm going to ask for a testimony, and then you can ask the relevant questions.
Fine,
Is that
but on behalf of the board, I would appreciate it if that question were answered on the record by the city.
Okay. So the return to work coordinator, President, do you have anything to add to your memo from May 8th, 2019 on the accommodation of work restrictions, or wish to present any other relevant to this issue, testimony relevant to these issues to be determined in the hearing? And if you would, please provide an answer to Mr. Lederman's question.
Also Cordova, Return to Work Coordinator with the City of San Jose. I do not have anything to add to my memo. With regards to the question that was asked, the city does not, they are two separate classifications. Police data specialist and police safety radio dispatcher are two different classifications. As previously provided, we have a different interpretation than what has been provided before the board today with regards to the language that is contained in the municipal code and the charter.
Thank you. Thank you, Elsa. Mr. McBride, please present your testimony in support of your application.
We are not presenting any testimony.
I did, so my item number 7, thanks to my vice chair, is, Dr. Chairman, did you have anything to add to your written report for the board's consideration?
No, I don't.
Okay, so now I've checked all the boxes. Mr. McBride, would you like to question any of the witnesses who have testified?
We've had one witness testify, and I don't disagree with her conclusion
Okay.
that they are different categories or classifications.
Okay, so there's no other questions, no rebuttals. Would the board members like to ask questions of any of the witnesses who have testified?
I think Mr. Requeta has a witness he wants to have.
Did you have a
testify.
witness you wanted to present?
I would like to put on the testimony of Ms. Andrade for the point of establishing that Ms. Pizzuti and her work restrictions could be accommodated in the position of police data specialist. Now, depending on the board's view of the underlying assumption that would make that testimony relevant, namely whether those two positions are in the same classification of positions as required under the relevant Muni Code provision. Depending on the board's view of that legal issue, that testimony may either be relevant or not relevant.
interesting. Okay, only because I love uncharted territory of having a committee ask for a witness. So is the committee asking for a witness, or Mr. Requeta asking for a witness on behalf?
Mr. Andrade, well,
As your counsel to the the Disability Committee, are you representing their request to present that testimony to the board?
yes.
That is correct, yes.
So the committee itself is witnessing is asking us to hear testimony about a classification description?
But I would like
correct?
to emphasize, yes, the statements by our council, which is, it will only be relevant after your board, I'm assuming with input from your general counsel, answer the question about whether or not they are within the same classification. Because if your determination is that they're not, I don't think then that there will be a need to have that witness testify. Did I explain that correctly?
Yes.
Yes.
And so Mr. Lederman wants to say something, so the question of, do we want to hear about a classification description if we think they're in the same classification? And Mr. Lederman?
If I may, the city coordinator has said that they are two separate classifications. Now, as I understand, the third point of the stipulation, at least on behalf of the applicant does not contest that she can be accommodated and do the job of police data specialist. So I'm not sure you need testimony to that effect if the applicant has already stipulated that, yes, she can do that job. So,
I apologize, because I know stipulations, particularly when they're just said orally, are somewhat confusing. But the stipulation is only that Ms. Pizzuti will not contest a finding. And for my purposes.
Could you repeat that again, please, Mr. Requeta?
The stipulation is that Ms. Pizzuti will not contest a finding. So I, out of perhaps an excess of caution, would like to present some testimony on the issue to the board so that it could make a finding on that issue as to which Ms. Pizzuti will not contest the finding. Again, though, there's still, I think, the point.
Mr. McBride? did you
May I
want-
suggest this, rather than have testimony, if Mr. Requeta wants to make an offer of proof as to what the testimony would be, so it's on the record, and that would take care of it.
If Mr. McBride thinks that will take care of it, far be it from me to disagree with that. And so employing that approach, we would make the offer that we would provide the testimony of Veronica Andrade, that Ms. Andrade is the Division Manager of Operational Support Services in the Bureau of Administration for the San Jose Police Department, that she has been employed with the city for 22 years, that she has been in the position of Division Manager for 6 years, that she herself in the past served as a police data specialist, that in her current position she supervises police data specialists, that she is therefore familiar with the duties of the position of police data specialist, that she has reviewed the work restrictions provided by Ms. Tierman and has compared the work restrictions provided by Dr. Tierman to the job position of police data specialist, and has concluded that the position of police data specialist can accommodate those work restrictions. That would be the offer of proof.
Does the board want to ask any other questions? Because we can close that part of testimony coming in, and we can deliberate. Does the board have any questions they'd like to ask of the witnesses that have been presented information?
Yeah, I have a question. Mr. Requeta, you'd cited the Muni Code on a number of instances, and then Ms. Cordova cited the code and the charter. And is there relevance to that?
Well, the charter as well as the particular Muni Code provision that is at issue in this hearing, which is a reevaluation context, but the relevant charter or there is a relevant charter provision as well as the reevaluation provision in the municipal code that contains the same key language, that someone can only be reinstated to a position, and I'm working off memory, so I may have a word or two wrong, but it basically says to a position in the same classification of positions plural. So the issue for the committee was the interpretation of, in this reevaluation context, of that language, which is the same language that is in the different municipal code provision that we considered in the prior hearing.
Thank you.
Yes.
I have a question to Ms. Pizzetti. Sorry, Pizzuti, sorry if I pronounced the name wrong. Do you want to come back to the city to work as a police data specialist?
I don't think that's relevant in this setting, because she is taking the position, she is not contesting that she could do the work. She's not agreeing to do the work, she didn't say she could do the work, she's simply not contesting the offer of proof.
So that's why, has she agreed to come back to work as a police data specialist? But if I hear you're correct, her answer to that question is no.
It hasn't,
She has.
currently it hasn't been offered, and she would have to make that determination. She is very concerned about any job in which her left arm is used continuously or repetitively, in terms of whether she could actually do the job. She's concerned about that. That's why she's not, for purposes of our proceeding today, she's not contesting that, but if it were offered, she'd have to make that determination.
Any more questions for witnesses before we, or any of the testimony before we deliberate? Okay, seeing none, so I'm closing the hearing for deliberation. So again, part of it is, so indulge me for a moment. Not all the trustees have been through all the disability process and not all, and been through these kind of deliberations before. At this time, we can decide and have discussion here about what our thoughts are, challenge each other, make a motion. I'd just like to make, so as I understand the litany of what's in front of us, and to be clear, is that we've heard a case from Ms. Pizzuti back in 2015, 2016. We denied, it went to court, it was approved. We accepted that decision and have been, and then video evidence came in that warranted us to review it again. We now have the position of our lawyers, or of our doctors, saying that she is incapable of performing the jobs and the classification in which she was in at the time of separation.
I just want to add is that I am not saying she's incapable. I have listed the work restrictions.
And they cannot be
It's
accommodated.
impairment versus.
They cannot be accommodated, is that correct?
Yeah, that is.
The latter is the correct statement? She cannot be accommodated based on the restrictions you provide, is that correct?
That is, of course, not Dr. Tierman's call. Her call is the work restrictions, but independently, yes, that is our assertion.
Okay.
Can I ask a question?
Sure, we're trying to deliberate and figure out the right answer here.
Thank you. And as part of the committee, so counsel for the committee offer Ms. Andrade to come and testify, and it appears you board elected not to hear her. And the only reason I'm raising that issue is because Attorney McBride just indicated one of the concerns by Ms. Pizzuti is about her left arm to be used repetitively, if I can say that correctly. And so I was just wondering, before you board deliberate, whether we can hear Ms. Andrade testify about the position of police dispatcher, of data specialist, but in particular, that particular question about the use of her left arm. I think it may be helpful for the board in helping you deliberate.
I think by the
this
board's
particular
lack
thing.
of interest in hearing the testimony is indication that they've heard that the classification is not the same classification.
Yes.
And so it's an indication of the board's interest in pursuing that tract.
Understood, thank you.
Unless the board thinks differently, unless they want to hear the testimony or go down that path. This is an interesting one.
Dr. Tierman, could you remind me, clarify for me, as a result of Sabrosa, the videos, what changed medically speaking, what changed as a result of the Sabrosa videos?
As I said in my initial testimony, that when people have pain and very little physical findings, we have to rely on the veracity and the truthfulness of the person. What had happened in the previous retirement board is that Ms. Pasuti testified that she couldn't do, and also to her doctors, several things. The video showed her doing these things, or many things like repetitive gripping, holding onto cell phone, etc. I think what's difficult is life is repetitive motion, number one. We use our hands all the time. We walk, we sit, we do everything. In the workers' comp setting, again, it's skewed in favor of the employee because they've given up the right to sue the city or any other company for no-fault insurance. And so to me, in Ms. Pazuti's case, we have pain levels 10, 8, low of 6. 6 is comparable to a severe migraine headache. That it's not compatible with the findings, physical findings that we see. No muscle atrophy, no disuse of that arm, and what the video showed. Because if your low is 6, that's still pretty intense. You really can't hold a job with a constant pain level of 6. Although there are times she says it's down to 3. And the other thing is that her condition, it might hurt a lot, but it will not damage her arm. In fact, the evidence, medical evidence, is to the opposite. If you don't use your arm, it's going to get worse. So I don't know if that answers your question.
It does, thank you. And then the pain associated with the condition that you agree on is it's constant, or it's
It can come and go, but it's unaffected by use. In fact, at the end, people tend to ignore that arm and sort of forget it's there.
Thank you.
Mr. Ricchetti, you want to say something?
Just to, I think this case is made difficult because I think there's two inconsistent elements that need to be sort of held in suspension. On the one hand, Ms. Pazzuti in 2015 made statements that were inconsistent with contemporaneous video descriptions. So I think the reasonable inference from that is that she's an unreliable historian back then and continues to be one. But that's on the one hand. On the other hand, and inconsistent to some, and the two cannot be confused, is that Dr. Tierman, even without factoring in any representations by Ms. Pazzuti, nonetheless concluded that she has, at the present time, serious work restrictions, sufficiently serious that that the committee has agreed to a stipulation that she cannot now perform the duties of police dispatcher, though, based on the evidence provided to the committee, concluded that she can perform the duties of police data specialist. So she does have serious impairment now, even if we factor in, on the other hand, misrepresentations back in 2015.
So this is a thing that's confusing to me. The committee is kind of talking out of both sides of its mouth and saying that in the statement here that the disability, so this is the second statement of your memo, the disability recommends the board finds Ms. Pazzuti no longer incapacitated with respect to the left elbow, and that her service-connected disability retirement be rescinded. That's that's the recommendation to us. So if we just accept that recommendation, we rescind the disability retirement. At the same time, you're saying it's not that, based on the restrictions, she is not capable of performing those duties. But she could do this other classification. And you guys should really listen to evidence about that other classification. So much so it's been said to us 3 times that we should listen to this other stuff about this other classification.
And the way.
And I don't know that this other part is relevant to us right now. So the committee is saying that they find that she's, that we should rescind it, that the service-connected disability should be rescinded because she's no longer incapacitated. We're hearing that the work restrictions are such that she is not capable of doing that job, but she can do this other one. Is that if I can nut down what
That's exactly right, because in our mind, the legal issue that's beyond the jurisdiction or scope of authority of the committee is the interpretation of this classification of positions issue. And so we've alerted the board
But you're almost
to that.
taking the leap of saying, hey, we don't know what to do, but guess what? You should go look at this classification. We don't know what our jurisdiction is on it, but we should talk about this classification. So many times, you've asked me 3 times to hear testimony on it.
Well, because this is the administrative hearing, so if we're ever going to get information, this is our
Yep.
shot. Number 2, we've also alerted you several times that we understand that there's a prior legal interpretation issue that needs to be resolved, and are also asking you to resolve that. Obviously, depending on how you resolve it, then the whole issue of police data specialist evaporates.
So, Leibman, did you want to make a statement before I make a motion?
Just an added piece of information for the board. And it's incumbent upon me as a member of the Bar of the State of California to tell you that in the prior court proceedings, when Ms. Pizzuti took the board's previous determination to court to have a ruling on whether the disability should or should not be granted, this board did not contest the interpretation of the law that says that the incapacity, the disability, must relate to the performance of duties in her specific job or other positions in that same classification. That was an issue that counsel for the applicant raised, and we did not, we were counsel of record in that court proceeding on behalf of this board, and this board did not contest that interpretation in this case for this applicant. So I want you to know that that is a matter that was previously established for this applicant on her specific application. That is, that the interpretation of the municipal code and the charter is that the disability is if the person cannot perform her job or a job in the same classification. The phrase "same classification" is what appears in the municipal code.
Thank you.
For
Mr.
the
Horowitz?
record, that's in section 3.28.1210 of the municipal code.
Mr. Horowitz?
Yes, is there a formal determinative listing of every single job in the city and its associated classification? Or is there some ambiguity as to whether a certain job is within a classification or another classification? Directed to the city.
I can, if you want to address that to me, I'd be
Well,
glad.
I'm happy to hear all.
You're welcome to present your opinion, but
Yeah.
I will ask Ms. Cordova to certainly
The
present
city
this.
has, and I don't have a current one, but I've seen the past one, has a list of every job and indicates the classification of those jobs. Some jobs, like certain clerk jobs, are all in the same classification. Other jobs, like a police officer, there may be 1 or 2 or 3, but there are specific lists, or a specific list of the jobs in the city of San Jose with the classifications.
Certainly, Ms. Cordova, you can.
Yeah, so the city has a classification plan or pay plan, which lists every classification or position in the city and provides class specifications for each of those positions. In addition, there are job families that have been identified for positions in the city that are also listed. Again, the city's interpretation of that municipal code language is very different, and, you know, we don't view that language to mean the exact same classification, but rather the classification of positions referring to the pay plan.
Does that answer your question, Mr. Horowitz?
Yes.
Any other deliberation from the board?
And we have established that every position that belongs to the public safety dispatcher, is that the right classification? Every position that belongs to public safety dispatcher has virtually the same job duties. They all virtually look the same, as opposed to other classifications such as office specialists. They could be receptionists, or they can be clerks in the back. There are, you know, I've worked for the city for 32 years. There are many classifications in which the positions within that classification vary. And I guess, Ms. Cordova, this might be a question for you.
My understanding is that, for instance, in the job of dispatcher, safety dispatcher, I believe there are 4 positions. One is full-time, one is half-time, one is number 1, and one is number 2. I think there are 4, all in the same classification. There are no other positions that are in that classification.
So within classifications, there can be different levels. So for police radio dispatcher, there is a trainee position, a level 1 position, level 2 position, and it goes up because there's a progressive way that an employee can promote through that job family. Each of those positions have certain specific specifications associated with it to differentiate one from the other, because each position has some differing duties while others may overlap.
But in terms of the strenuousness in this particular situation, in terms of the strenuous, they are all virtually the same.
If you're referring to, well, it would differ, because if you're in a senior position or a supervising public safety dispatcher position, then your duties differ from a radio dispatcher to some degree. Not that you're not taking calls, but there are other functions that you're doing.
Any more questions?
I have a question.
I have a question. And the city determined that within the same classification, the part-time position was not sufficiently accommodative of the disabilities. Is that correct?
We didn't specifically look at a part-time position for Ms. Pizzuti when we engaged her in the interactive process. When we engaged her in the interactive process, we looked at, I should say that we were going off of restrictions that she had at that time, and we looked at other positions that she could perform and identified the PDS position as the position that she could be accommodated in, and she was offered that. She took the test for that position, passed the test, and was offered to be placed in that position and rejected that offer. So she did not accept the city's offer to place her in that position, and instead continued through the retirement process.
And you say, quote, "at that time," was that before or after the Sub Rosa video came to light?
That was before.
Ms. Sun?
Well, I just wanted to hear from Dr. Tierman, that do you agree Mr. Pizzuti cannot perform the duty as a police radio dispatcher?
I hate to punt, but that's really not my call. The only thing that because physicians do impairment, I did see what the police dispatcher did, but for 3 hours. That's not fair to Ms. Pizzuti or the department. What the other thing I want to stress is that these restrictions are for the right arm only. I'm sorry, left only, not for the right. So she has no restrictions for the right arm. And I don't know if that makes a difference or not.
Well, I just find that the Disability Committee made a determination that she cannot perform the duty as a police radio dispatcher. I don't really know how they make the determination, because that's a mess to me.
What it says right now, that she's no longer incapacitated, meaning that she is able.
Yeah,
That's
that's
a-
why,
yeah.
but they're insisting putting her into another
Oh.
class. Why?
I'll slightly, I don't think they're insisting, I'm thinking they're saying, look over here a lot, is what I'm hearing. No,
Yeah, you know, I
multiple
mean-
times, look over here.
It,
So, Mr. Rekieta, I've got a motion I'm going to make here.
Interested, we could present the relevant witness for the police department, who will say unequivocally that she cannot, that the position of police dispatcher cannot accommodate those work restrictions. We certainly didn't enter into this stipulation lightly or without deliberation or without consideration. It was only because the facts support that stipulation that we entered into it. But if the board is interested in delving into the facts that underlay the stipulation, that there is a witness who will readily confirm that. And I personally spoke with that witness.
Thank you. So, please listen carefully to my motion, because I'm trying to be clear on this. I'm going to make a motion that we are not going to rescind the disability retirement for this particular applicant as recommended by the Disability Committee, because as has been stipulated here, she cannot be accommodated in the position of police radio dispatcher. And because we have, as Mr. Lederman pointed out, not contested the position that was made in the Superior Court finding. That is my motion, and the reason for my motion for not rescinding the disability retirement. Is there a second to that motion?
I second.
Okay, so we have a second. We're certainly welcome to discuss alternative motions, substitute motions can be put in if someone disagrees. Again, I'm trying to help the board try to navigate through this. Is there a substitute motion? Do you have questions, clarifying things that my motion not clear as to the reasons?
is it possibility for me to abstain?
That I don't know. Is there any, are we obligated to give an affirmative or?
No. As a matter of governance of a pension fund, the board's trustees are placed on these boards to take action. Actually, the state constitution talks about the board shall do certain things of a pension fund. Abstentions deprive the board as a whole and the system as a whole of the action of board members who are put there for a reason, to consider, deliberate, and take action. If there's a reason for abstaining because you're not familiar with the material, or you have a conflict, for example, or some good reason why you don't wish to participate in making a decision of the board, that's certainly appropriate. I would encourage all board members to actively participate in decision-making as board members, particularly in a situation where there are so few board members on the board, and we have one vacancy already here, so that it's important for the board, if there's more clarification, more information that
A
the board
substitute motion,
members
something you
need.
disagree with, you can
or
vote
s-
no.
or
And
something
that,
else.
yeah, you can vote no, you
But-
can
but
say
I
that you
would- yeah.
disagree with what I'm saying, present a substitute motion that you think is more appropriate, that you would support. or I could take a matter of vote on this one, and we could see where it lands, and so.
Right.
Okay.
I will also point out, Mr. Chairman, as a matter of just in terms of what appears on the agenda, there is a recommendation from the Disability Committee to cancel the allowance. If the board takes no action, then the matter just dies. And so among the options that you have are to take actions to accept the recommendation, to decline the recommendation, to take no action whatsoever. A vote of no action, in other words, if there were no motion pending, then there would be no change in the applicant's disability retirement benefit, and we would go on with other agenda items. So there's not a requirement that you take action or not take action.
Mr. Chair, may I ask a question again of another question of a witness?
I guess, sure, why not? If it helps us get to the right answer, what I
Ms.
want is the
Cordova,
what I want is the right answer.
Could you
My
please come
apologies.
back up to the microphone? Thank you. While you're walking, both Mr. Liederman and Mr. Requeta quoted language from the charter about, and somebody can give it to about the position, the classification. That, as I hear it, it sounds very literal and narrow in scope, yet you've said a couple times in this case, in the prior agenda item, that the city's interpretation is different, and what is the foundation for the city's interpretation being different from what appears to be fairly narrow?
Well, again, the class is defined in the municipal code, and I think that one option before the board could be to refer this matter over or seek an opinion from our city attorney's office, as they are best equipped to provide a legal opinion related to the municipal code and the charter on behalf of the city. We have not interpreted that language to mean what has been described here. And that might be a course of action available. I understand that this was not contested when this issue went before the Superior Court. However, it is coming up in these cases, and that is something that could be explored.
Just my response about it before we vote, my response to that is, while I believe that broader interpretation for the purpose of creating opportunities to have injured workers continue to work, it's good for the employee, it's good for the organization. It doesn't seem to be binding for the purpose of disability retirement.
And that is where I would, I've given you our position on it, but if you would like a legal opinion or argument on behalf of the city, I think that's more appropriately addressed through the city attorney's office.
Okay, we have a motion and a second. Is there a substitute motion, or is there so basically a substitute motion takes the place of the existing one, and we'd vote on that, or would you like to vote on this motion? Entirely.
Well, just sort of thinking aloud based on Trustee Castellanos' question and answer, could there be a motion to not take action subject to an interpretation by the city attorney? Or is that non-responsive to the issue before us?
So a non-decision can happen, we can make the decision as motioned, a different decision, or we could defer this item to a further meeting to a decision if you wanted to seek legal counsel. And again, my guess is, looking at Mr. Liederman, that he would probably counsel us that the city attorney's counsel is not necessarily the only bit of information we'd want to consider, but certainly we want to consider something from his end as well, as to how we should be viewing it from both ends. If we wanted to seek information from the city attorney's office, I don't think there's anything precluding for us, but we also have our own independent counsel here to advise us on this as well.
Can I make a, what's called substitute?
Substitute motion. Mhm.
Can I make a substitute motion?
You can?
I would like to make a substitution motion to defer the decision on this matter with additional evidence from the Disability Committee. I want to see how they I want to find out how they determine Mr. Pizzuti not able to perform the duty as a police dispatcher specialist. That's her original job. Because based on the medical evidence and explanation explained by Dr. Tierman, I am not fully convinced that she has the physical restraints to perform as a police dispatcher specialist.
So, just to be clear, the motion is to defer the decision to seek more information purely from the Disability Committee on the reason why they, again, I'm just trying to reiterate, so if I got it wrong, so why they believe she is incapable of, or sorry, the restrictions do not allow her to perform the job of police radio dispatcher, or police radio specialist.
Dispatcher.
Dispatcher, my apologies, dispatcher. That's the motion?
That's my motion.
Okay, is there a second? Okay, that motion dies for lack of a second. Okay. Great exercise in governance. So, I appreciate the patience. Did you-
The original motion.
The original motion is still on the floor. Would you like to vote on that, or is it, again, I'm not trying to provoke another answer, I'm just trying to make sure that you have the answers at your disposal, so you make, again, the goal is to make the right decision, not to make Matt's decision, or a particular decision.
Well, in light of that response for my substitutive motion, I vote to accept the cancellation of allowance.
Vote to accept the cancellation of the allowance? So the motion,
Accept the disability committee recommendation.
okay, so you're presenting another substitute motion?
No, because you're saying my
oh,
substitute motion died.
So you
So
want-
I'm going to vote on this.
Okay,
And so
Okay.
my vote on this is accept the disability committee's recommendation.
You're accepting his original motion.
no,
No.
stop.
No.
So, the motion on the floor is to, okay, is to deny the Disabilities Committee's recommendation to rescind the application, to rescind the benefits. That's the motion on the floor. It's been seconded. All those in favor? Aye.
Aye.
Aye. And was
I
it?
say no.
And there's one no, so it's 4-1 no. Yes, thank you. Thank you for your time and patience getting through this today.
Thank you.
Okay, I'm going to call a 10-minute recess. We're going to reconvene at 11:12 on that clock.
I know
We are done with all the items up to item 4. Item 4 is the 4A is the oral update from the CIO, Mr. Polani.
Thank you, Mr. Chairman. Firstly, let me start by thanking you for your
You
services
missed
to
your
the
time, it was
board.
earlier. We're all done.
I'd already told Roberta I'd use my oral update to do that. So anyway.
The chair objects. Please go ahead,
CIO
sir.
overrules. But I first came to know Matt as a trustee of this board, and he was very welcoming and generous with his time and advice, and that has followed through my position as CIO. And I really will miss your advice, your candor, your wisdom, and all of those good things. And if I may say so, Matt is just one nice, decent human being, and there's not enough of that in the planet. So,
Wow.
with that, I will move on. So last month, we heard from Cheryl Parkman about the climate emergency resolution passed by the city on fossil fuel exposure. So we quickly looked at fossil fuel exposure in the Fed portfolio. And a quick calculation showed that we have, on the public side, we have a $38 million exposure to fossil fuels. And that's about 1.3% underweight to the benchmark allocation. And most of our active managers are actually underweight fossil fuels. And a lot of the dollar allocation, in fact, 22 of the 38 million actually comes from our passive holdings in fossil fuels. And I would also like the board to know that we did 2 education sessions on ESG, which is a broader topic. And fossil fuel is one narrow subset of that at the investment committee level. And it is my intention in calendar year 2020 to bring those education sessions to the full board. With that, I'm happy to take on any questions. If not, we can move on to Makita.
Any questions for Mr. Polani? Okay, seeing none, on item 4, I'm just going to open all these up for you. So item 4B, the presentation, calendar second quarter 2019 private markets by Makita, calendar year second quarter 2019 private equity report by Neuberger Berman, so that's not necessarily you on the line. But then you also have this is D, the calendar quarter, third quarter performance from pension from Makita, and E, the healthcare from Makita. So please take the floor.
Thank you. Good morning. We have first the private markets report. As you know, the private markets reporting has always lagged a quarter relative to public markets due to availability of data. This is also the public report, and staff receives a more detailed non-public report that has more information on specific underlying investments. So we will start on page 3 with an overview of the performance. You can see the legacy private equity portfolio, the Neuberger Berman Fund of One, and then the 3 individual private markets asset classes: private debt, real estate, and real assets. You may notice that our net IRR here for the Neuberger Berman is slightly different than the one that they're going to present. We used their underlying data. We confirmed it with San Jose investment staff. Our assumption is that maybe some small flow came in at the end of the quarter to make it slightly different. So Neuberger Berman is presenting an 18.5 IRR for their program, and our calculations show 19.1, but this is something we're all aware of and likely just didn't receive some cash flow from Neuberger Berman and they're reporting to us to put this together. I'll start with the private debt program on page 8 in terms of the individual programs. In the second quarter for private debt, the total market value for this program stands at 3.1% of your total fund. That's relative to a 4% target. There was one new commitment, you can see at the bottom of the page here, in the second quarter to work towards getting this closer to its target, $18 million to Cross Ocean European Special Situations Fund 3. During the second quarter, $14.5 million was called by these funds into this program, $4.8 million was distributed. So it's essentially self-funding, just pulling back in the distributions that are coming out of existing funds. If you recall, the 3 funds at the top of this page were originally part of a different allocation. They were pulled into private debt later on. They're all from almost 10 years ago now, and they're all designed to be direct lending funds, which are more conservative and generally have a lower return assumption than the other funds that have been added since. They still, however, because that's a large allocation, 150 million out of 215 million total committed, they still sort of dominate the overall performance of the program. Eventually, they will sort of roll off as the newer funds that staff and Makita have recommended more recently become more mature. You can see the one fund that's sort of part of the newer class of funds in vintage year 2016 is Cross Ocean US Dollar European Special Situations Fund 2. It has a net IRR, if you look over on the right, of 8.9. That's outperforming the benchmark net IRR of 7.7. The rest of these more recently committed funds all have reported fair values above the contributed amount of capital, which is a good sign. Happy to answer any questions on private debt, or I could skip ahead to real estate on page 14. Okay, so the real estate program is at a 2.7% allocation relative to a 3% target, so very close. During the second quarter, $13.7 million was called into the program and $3.4 million distributed. You can see at the bottom, there's a 2019 fund on here. There was yet another fund that was committed to after this report was put together after June 30th, and it's DRA Fund 10. If you take a look at the other funds on this list, the plan has committed to many DRA funds, and they performed very well for the plan. This is the sixth DRA fund that you all have committed to. If you look at the real estate funds as a whole, every single one of them is outperforming their benchmark IRR except for one. That's the GE Asset Management Fund from 2006 that's now 13 years old. That was not a great year for real estate commitments back in 2006. Otherwise, the other programs performed quite well. Take any questions on real estate or skip to real assets on page 21. Okay. So on page 21, you can see the summary of the relatively young, immature real assets program. It's something that we've been focusing with staff on building out over time. There were 2 new commitments in the second quarter of 2019, which you can see here, a Global Infrastructure Partners, or GIP4, on page 21, and also Kimmeridge Energy Fund 5. So those 2 funds were a $7 million commitment total. Right now, the real assets program is only at about a 1% weight relative to a 3% target. So we're still funding up this program.
Your conference is ending now. Please hang up.
Still funding up this program over time. In the second quarter, $0.8 million were called and $0.3 million distributed. There's only one fund here that's mature enough to have a performance number so far. It's GIP3. But performance is very encouraging. The net IRR is 7.7% relative to 2% for that benchmark year. So I'm happy to take any questions on the private markets report as a whole.
Mr. Horowitz, please.
Yes, going back to the debt.
Yes.
Total net IRR 3.9%. What is the duration of this total portfolio?
So private debt funds individually usually have about a 2 to 3 year commitment period and a shorter overall life than other private markets. So typically a private equity fund will have a 10 to 12 year total fund life. These funds are usually shorter, usually more like in the 5 to 7 year range. Oh, hi. So Brian might want to answer that question as well.
In terms of interest rate duration, typically much less than that also. The vast majority of the assets that end up in those portfolios are floating rate securities. But as Laura said, the term of the vehicle is a better indication of our length of time that we'll be invested in something.
Could I ask that the term be added to this matrix for future presentations for the various vintage years so we can understand a bit more about how to evaluate the net IRR for the individual investments?
That's something that we could provide to you on a private report. For our private investments and all of our alternative investments, we present what we're mandated to present by law in open session, but we have a lot of confidentiality requirements around details on the particulars of each investment.
I guess I'm curious, I'm hearing those words for the first time.
What's that?
The mandate, where does that arise from? About what they can and cannot present?
It's more of a preference from the underlying investments. So, some private markets funds do not allow investments by public entities because they don't want to release more information. So we try to present what is required in the public forum so that we're able to get access to private markets funds that do not want, all of their information out in the public domain.
So this is a requirement from the investment vehicle not to release the information publicly?
The manager itself, not necessarily the general vehicle. If we want access to that general vehicle, likely the subsequent managers often have NDAs that prevent some of the public disclosure of it. Staff has full vision into all of it. So I don't know if you want to provide additional detail, Brian.
Yes, so, what we present in the performance reports is, there are
Brian,
requirements
just
in the code.
can you speak into the microphone, please? So, I'm sorry.
Yeah, so what we report in this open session format is everything that allows people to evaluate the performance of the investments that we've made. And then, certainly any information that you would like to know, we know everything about these, and we spend an extensive amount of time negotiating things like how long will we be in that investment. It's just something that most investment managers and their underlying portfolio companies do not want in the public domain.
Okay.
And if I may just offer to Trustee Horowitz that we can sit anytime you'd like one-on-one and discuss greater details on specifics.
Okay, thank you.
Yeah, was there another question? Trustee Sun, did you have a comment? Okay. More? Okay, going on to Newburgh Berman, or are you finished? Okay, this is on to item, we need to have them call in again? Okay. Why don't we do this? Can we go on to your item D and do the
So
pension?
I believe the host has to dial into the
Right,
call
so
and then.
why
Yeah, yeah.
why don't we
Then
just
we'll-
go on to
we'll
item
shoot
D first and then come back to the Newburgh Berman part?
She's on the line.
Oh.
She's just waiting for the host to dial in.
Okay. Well then you can sing for us. Entertain us some more.
You don't want to hear me sing.
Call, including you. You are joining your conference as the host. For a menu of available commands, press *#.
Casey, are you on the line?
Hi, I am on. Can you hear me?
Yes, sorry about that. So I believe we are ready to go on our performance report for private equity.
Okay, great. That was a little bit quiet, but I assume it's my turn, so I will go ahead.
Yes, please proceed.
Casey Boyer with Newburgh Berman. I'll just take a minute to, again, thank you all for being given the opportunity to present to you quarterly. I will just hop right in on page 1. This is the Q2, so June 30th, 2019 performance. Page 1, we just like to give a good overview of the legacy private equity investments as well as the investments that are being made through the Newburgh Berman program, and then a combined result. So on the legacy, the only thing I would mention is a lot of those investments are 10 to 12 years old at this point, so a lot of value has been realized at this point, over 180 million distributed, with a little over 40 million of NAV, so 40 million of unrealized value. For the Newburgh program, we are currently about 68% committed, and of that 177 million that we have committed to underlying investments, approximately 32% of that capital has actually been invested at this point. So a little over 56 million of capital contributions. This quarter, there was, and there is one difference. We actually have been able to distribute a little bit, so a little over 2 million of distributions have come back to your program. That was primarily from an early partial realization from a co-investment. So that is always good to see those early realizations. In terms of a total net multiple, this quarter, it's currently being held at a 1.2 times. So that's a good overview. I'll turn to the next page, page 2, and of course, feel free to interrupt me if you have any questions. Page 2 is a performance versus the benchmark that we like to show. So these are the legacy investments, and at the top of each section, you will see the return metrics for that specific investment, along with the benchmark underneath it. So you can see on the right-hand side, second quartile, third quartile, how these investments are performing against their relative benchmark. As I mentioned earlier, a lot of these funds are from older vintage years, 2006, 2008. So a lot of the performance is already kind of baked in, and there's not too much movement from quarter to quarter. Moving on to page 3, this is the same analysis on the Neuberger investments. As you can see, a lot of our investments are relatively new, so the benchmarks are not yet available for vintage years 2018 and 2019. A majority of our investments are 2018 vintage year and on, so there's not a huge ability to show all of these benchmarks at the moment. As time progresses, of course, we will show these, but you can see the top 2 investments, vintage years 2016 and 2017, and how those relate to their relevant quartile benchmark. Moving on to page 4, this is meant to show essentially the investment pace and how your investments are lined out by the vintage year. So if you look at the top right, this is the Neuberger vintage year analysis, and you can see how we've started investing, and 2018, 2019 continue to put capital to work. As we continue this program, this will become more diversified, and you will see continued vintage years on this pie chart. Moving to page 5, this is a similar analysis, but instead of using the commitment amount, it's using the net asset value. So this shows on the Neuberger side, a good portion of the net asset value at this point is in 2018. As 2019 investments continue to deploy capital, you'll see that grow. And of course, as we add investments over the course of vintage years, you will see a little bit more diversification evenly over years. Moving on to page 6. This analysis shows the performance of the investments by asset class. So on page 6 and page 7, you also see venture capital. This is very much what we would expect, specifically on the Neuberger side. Investments are still deploying capital. Performance should gain traction from here. But seeing early performance in special situations is kind of on track with what you would expect by asset class. And as you can see on page 7, venture capital, as we all know, venture capital does take a little bit more time. And so right in line with what we would expect again in terms of performance. Page 8 is a similar analysis, but it is done by investment type. So primary fund investments, secondaries, and co-investments. One of our key investment philosophies is to incorporate secondaries and co-investments into our programs because it really does help mitigate the J-curve. It puts capital into the ground efficiently, and you will likely see those earlier performance. So that is what you're seeing here. Co-investments tend to be, you know, if we pick good ones, which we hope we do, you'll kind of see that return step up quicker than some of the primary funds. Page 9 is page 9, 10, and 11. This is the same analysis, but instead of using the multiple of invested capital, which I just spoke about, these are using IRRs. Moving to page 12, this is a status of the portfolio report, which shows all of your underlying investments and very specific contributions, distributions, and fair values of each one. So you can see what investments are driving value, and you can kind of see the growth IRR and growth MOIC as well at an underlying level. On page 13, at the very bottom, you'll see all the totals. So you can see everything broken out by legacy investments, Neuberger investments, and then, of course, totaling all those together. I'll just give you a little bit of background on Q1 of last year. The Neuberger gross MOIC was 1.15. This quarter, it's 1.17. So growing, and hopefully that performance will continue. So I'll just go ahead and open up to questions.
Can I ask a simple question? This is Chen Yu. Casey, can you give me a simple definition on the private equity category, primary, secondary, and co-investment? And I also have another question is regarding when you label some of the private equity investment as special situations, what are those special situations?
Yeah, sure. So in terms of investment type, primary funds, secondaries, and co-investments. Primary funds are when we are making investments directly into a private equity fund. So when they are fundraising, we, make a investment into their fund during their fundraising process. Secondary investments are essentially buying commitments on the secondary market. So if someone wants to get out of their private equity position, we could go in and buy that position, depending on the market, likely at a discount. But again, that's just dependent on the market. And then co-investments is where we actually invest directly into a company alongside a private equity sponsor. So working directly with a private equity firm to help them diligence a co-investment or a portfolio company investment, and then investing alongside of them into that investment. So those are the investment types I mentioned, and those are all utilized within the program that we have with you. And then your next question was special situations. For us, special situations can be a big bucket, and it can be rather dependent on the market. Currently, what it means for us is essentially turnaround investments or deep value buyout investments. So we like to say there's never a point in time where there's you can't find a company that needs help, whether it's from a capital structure, management team. There's always companies that are poorly managed, and so we can come in or a private equity fund. We invest in private equity funds that we consider special situations, where essentially they have the expertise to help companies turn around a bad situation. So that is primarily for us what it entails right now.
Okay, thank you.
Mr. Horowitz.
Trustee Horowitz here. Looking at the private equity partnerships, would you care to comment on investment number 35, which has had a fairly rough ride so far?
Yes, 1 second. So 35, yes. I have a different presentation in front of me, which doesn't actually have number 35. I assume you're talking about the second investment on page 3?
Correct, 2017
Yeah.
vintage. Yep.
Yes. So that is what's happening there is essentially what I mentioned earlier, which is a J-curve effect. So that investment, as of 6/30, had one investment. So the fund overall was less than 10% committed, and at the same time, the management company, the GP, had started to call capital for fees and expenses. So while that one investment is held at cost, there's also some fees and expenses that are being paid. So technically, the value is less than 1, not necessarily because there's bad investments, but because the timing and because there's not a lot of investments into the fund. And so that should change pretty quickly as soon as they make another couple investments and maybe 1 or 2 of them are written up slightly. But that's something that, is easy to see in primary fund investments at the very beginning of the life cycle.
Okay. Other questions for Newberg or Berman? Seeing none, thank you. On to the next presentation, please.
Thank you.
Thank you very much.
So we have the quarterly review here as of September 30th for the pension, for the retirement system. So I'll start with a really brief market overview on page 4. During the third quarter of 2019, real estate investment trusts were the strongest performing asset class. They do pay dividends, and that is something that makes them attractive, especially in a low interest rate environment. That was followed by investment grade bonds, the Bloomberg Barclays aggregate up 2.3% for the quarter, the S&P 500 up 1.7%, high yield bonds, TIPS, and then the Russell 3000, which is the broad U.S. equity market. If you look at the negative returns, several of these asset classes are non-U.S. currency-based asset classes. The dollar did hit a high during the third quarter. If we look at about half of the fourth quarter to date, as we sit here in sort of mid to late November, so since September 30th returns, we see a trend that's happened quite a bit this year, which is that one quarter, certain asset classes are down and others are up, and then that completely reverses the next quarter to date period. So far, with the fourth calendar quarter of the year, the S&P 500, continues, U.S. equities continue to be the strongest performing asset class, up 4.7% for the quarter to date period. But we also see the MSCI EAFE index, International Developed Equity, which was down over 1% in the third quarter. So far in the fourth quarter is up 4.4%. And of course, the worst performing asset class in the third quarter, which was emerging markets, down 4.2%, has been the best performer so far in the fourth quarter to date, up 5.3%. We have seen 3 interest rate cuts by the Fed during 2019. The last one that happened had about 100% market implied probability of happening, so everybody had sort of priced it into the markets. The Fed does meet again in December, and so there's about a 50% market implied probability right now of another Federal Reserve rate cut in December. The chair of the Federal Reserve, Jerome Powell, was speaking last week and indicated that he didn't think it was necessary, but of course, we know that things can change quickly. Growth for the third quarter came in at 1.9% for GDP growth. That's been driven almost entirely by the consumer. Companies really aren't investing right now, and the theory on that is that it's because of the trade war. One of the reasons for positive returns outside the U.S. during the fourth quarter to date, they're attributed to the fact that it does now look as if there might be a more positive resolution to the trade wars that we've had recently coming sometime soon. We do have incredibly low interest rates right now in the United States. However, if we look across all other developed economies, the United States rates still look pretty attractive. Our growth also looks pretty attractive as well relative to the rest of the world. So I'll get into your specific portfolio and just skip ahead to page 22, where you can see the asset allocation. As always, we've included the watch list and an executive summary, some comments on the individual portfolios, but in the interest of time, I'll skip to 22. And where you can see that the total planned market value was $2.1 billion as of the end of September. All asset classes were very close to their targets and within their investment policy statement ranges. On page 23, you can see total fund performance and asset class performance across the plan. You can see that for the quarter, which is also the fiscal year-to-date period, returns were slightly positive. If you look at the calendar year-to-date, the YTD column there, the third one, for 2019, from January 1 through September 30, the plan was up 9%, outperforming both the policy and investable benchmark portfolios. If you look at the one-year period, the return was 3%. If you recall, we had a very rough market environment in the fourth quarter of 2018. If we look at peer relative returns, the story remains that U.S. equities have dominated. The retirement system is underweight U.S. equities. Also, there's a lot of short-term bond exposure, and as interest rates have come down relative to peers, volatility has been a lot lower for the retirement system, but the peer relative returns have been challenged. If we do look at the full one-year period, the peer relative return is in the 65th percentile, somewhat below median, but that's really a market environment where you had that really negative market environment in the fourth quarter of 2018, and then this strong upswing thus far in 2019. If we look at individual asset class returns, generally public equities, especially in the US and globally, did quite well for the year-to-date period. If you take a look at global equity, which is 9% of the total retirement system, the return was 18.7% for the year-to-date period. That's nearly 3% better than the global market index, the MSCI All Country World Index. For U.S. equity, the return for the year-to-date period was 18.9% and was slightly positive, up 0.3 for the quarter. If we look at the next page, you can see that non-U.S. equity has been quite challenged. Part of that's currency, part of that's market sentiment. Marketable alternative equity was positive for the quarter period and also for the year-to-date period. And then we talked about the IRR-based performance for private markets, but you can see here the private markets performance on a time-weighted basis. In particular, private equity was up 17% for the year relative to 7.8% for the benchmark. A lot of that return is because you house your uncalled assets that are dedicated to private equity in the Russell 3000, which is U.S. equities, which has performed quite well. You can see other asset classes on the following couple of pages, but I think it probably makes sense to highlight a few managers, if that's all right with you, starting on page 27. If you recall, the overall strategy that Makita and staff generally subscribe to with manager selection is that it makes sense to go passive, use an index fund where it's cheap in asset classes that are efficient, not to hire active managers that are just going to sort of look like the index and try to eke out a bit of return, but try to hire managers that are usually more concentrated, are going to take different risks than the index would, and hopefully outperform over the long term. That's definitely been the case with your two Artisan funds within global equity, Artisan Global Value and Artisan Global Opportunities. If you look over on the far right side of the page, they both very significantly outperformed their benchmarks since you hired them. in 2011 and 2017. In U.S. equity, Cove Street Small Cap Value is a manager that has pretty huge swings and a lot of volatility. They looked pretty terrible a couple of years ago. They came back quite a bit. They did have a rough quarter during the third quarter of 2019. It's a very concentrated portfolio that does not hold very many stocks, and so when they hold one stock that's challenged, as many value stocks have been recently, that contributes to performance. But if you look at the year-to-date and one-year performance relative to their benchmarks, Cove Street has been doing quite well. I'll highlight on page 29 that there are two new managers in your portfolio. They're GQG Global Emerging Markets and they are RWC Emerging Markets Equity, and then on page 30, Wellington Emerging Markets. Dimensional in your emerging markets portfolio is a value manager. Value has been incredibly challenged, but luckily we have paired them with GQG Global Emerging Markets, which has had very strong performance. If you look on the far right, since you hired them in July of 2017, they've about tripled the benchmark and even more than that relative to the peer group, and are in the top decile of their peer group. And so that's helped to balance out some of the poor returns from value style stocks with DFA. The two new managers you can see here, RWC and Wellington. Wellington has about double the weight of RWC. It's more sort of a core position, whereas RWC has a bit more volatility and is more of a satellite position. Of course, both of these managers were funded at a great time. Sometimes it's better to be lucky than good, and you can see on the far right that it was a falling market environment for emerging markets, and so the fact that you all invested new capital at the right time means that you're in the top first percentile of the peer group with that very short performance history thus far for these two managers. I went through the IRR performance of all of these private markets investments, so I'll skip ahead to page 34 where we get to public emerging markets debt. This has been a good area to be for the year-to-date period. Blue Bay was up over 10% for the year-to-date. Iguazu is a new manager. This is a fund offered by Wellington. If you look on the far right, they were just funded 5 months before this report was issued, or 4 months before, so a short track record for Iguazu thus far. Absolute return has performed as we would expect, a year-to-date return, which is actually very strong relative to the absolute return benchmark. On page 35, you can see absolute return is up 7.7% relative to its benchmark at 1.9 for the year-to-date period. Core real estate has been another bright spot in the portfolio on page 36, up 1.2% for the quarter, so one of the stronger absolute returns for the third quarter of 2019. Up 5.1 for the year-to-date and 7.3 for the one-year period. Some institutional investors will group their core real estate with private markets real estate. However, it is quarterly liquid, and these are open-end vehicles, so in your plan, they are grouped here on the public report. Commodities has been an area that absolute performance has not been strong, but the way that you access commodities on page 37, which is through the Credit Suisse Risk Parity Index, has meant that they've protected quite a bit of value relative to the broad commodity index. You can see for the fiscal year-to-date period, commodities are down almost 2%, and this portfolio has been positive. I have an estimate for the past quarter-to-date period through yesterday. We estimate that October was up 1.4% for the total pension, November up about another %. So that brings us in the past 6-7 weeks to another 2.4% return, brings us to 2.6% for the fiscal year-to-date period, and 11.7% for the calendar year-to-date. We have a lot of other exhibits in the presentation here, but in the interest of time, I'd be happy to take any questions.
Any questions on the pension quarterly report? Seeing none, moving on to the healthcare.
Great. So healthcare, I will summarize starting on page 21. The total value of the fund as of the end of September was just barely under $300 million. Now with returns since then, we estimate that it is over $300 million. All allocations are relatively close to their policy targets and within their investment policy statement ranges. On page 22, you can see that the healthcare trust was down very slightly, negative 0.2% for the third quarter and the fiscal year-to-date period. It was up 9% for the year-to-date period between January 1 and September 30. If you recall, this peer group for health and welfare trusts is not very similar to your fund. Your fund actuarially has an assumed rate of return that needs to be similar to the pension. Many healthcare funds have a much lower expectation for their return and therefore are much more conservative. So generally in really up markets for equities, your fund or risk-on environments, your healthcare fund is going to look very strong relative to peers. In more negative or challenging market environments, we'd expect it to look less favorable relative to peers. The story with individual managers starting on page 24 is generally the same as the pension. The healthcare trust uses a selection of the managers that are public and liquid that the pension does. So I won't go into individual performance of those managers, but we'll note that our expectation for returns here is even higher because of all these public equity managers and the risk-on environment we've had since September 30. We estimate the October return was almost 2%, November up another 1%, for a fourth quarter to date return in the past 6-7 weeks of 2.9. That brings the fiscal year-to-date period to 2.6% and the calendar year-to-date to 12.1. So happy to take any further questions.
On the healthcare trust?
Thank you for your time.
Appreciate it. Okay, moving on to item 5. This is discussion action on assigning one trustee to the Joint Personnel Committee. Seems like we're picky choosy on some of the committees. The reality is, these are ex officio positions generally, except for one. So if you remember, the Joint Personnel Committee has the chair of the board, the chair of the IC as the two people on it. And if the chair of the board is let's say a plan member, generally the third person is a non-member. You basically try to balance it out so we have, because it is a joint committee with the Police and Fire Board. It's the only true joint committee. Sometimes we meet jointly. This one is an actual joint committee. So the chairman of the Joint Personnel Committee is actually the chairman of the Police and Fire Board right now, and the vice chair of that is Anurag. And so with my term coming out November 30th, I should say 11th and be done, but November 30th, I won't be available for any December meetings should they need it. And so the idea was that they wanted to have a third person appointed for the month of December to be available for the Joint Personnel Committee. The activities right now that they're working on is some of the personnel review policies of the CEO, CIO, and there's some heavy policy stuff around those two positions, both the review and management of those positions. And so they're trying to get some stuff done in December and wanted to try to reduce the risk of having a quorum problem prior to you guys getting all situated post-Mat. So right now, so Jay was appointed last month and Anurag is on it. So those two are out. So it's one of you three is basically what they're looking for. Who would like to be on the Joint Personnel Committee? Have at it.
Don't we have the new guy? What's his name?
Mike Kelleher?
Yeah, can we vote him in?
Well, it's hard to vote someone who's actually not a trustee yet.
Yeah, he's not a trustee. He hasn't been appointed even by the city council.
It seems that based on demographic, that the Chair Lesh just described, that Chair Lesh being an active employee, trustee son, it might be a good replacement.
No, not necessarily, right?
Well, public versus employee versus retiree.
Okay.
So we have a public and retiree on now.
Is that stated in our government's document? Has to be,
Well,
well, Jay,
the-
are you joking?
Two of the positions are ex officio, meaning the chair of the IC and the chair of the board are both on there. And depending on what that mix is, they try to make sure, so if both of them were employee members, or, then the participant, then the third person should be a non-participant. If it's balanced like it is, it's, meaning one's a participant, meaning the retiree is on there, well, actually,
Yeah, Jay's a participant.
again, you guys
Yeah,
decide.
Jay is a participant, and Anurag is a
He's a-
outside member,
Yeah, and then he-
non-participant. So I think that's the basic idea, to have members from both sides, and we already have them now. The third one, I would say at this point, could be either one, a participant or non-participant.
Who's interested in telling
Yeah.
Roberto and Prabhu what to do?
Yes, that's really the bottom line. Telling me and Prabhu,
A non-trustee?
yeah. At this point, we're taking pretty much anyone. As Prabhu is just gonna start his lunch.
Well, and whoever becomes the chair for next year automatically takes this position. So it's
Yes.
really to fill the bill for the month of December and to help get some of the policy work done.
I'm happy to do that.
There we go.
Thank you, trustee Orr.
So we have one person raising their hand, so is that is that a motion for yourself, nominating yourself?
Just for a while, though.
Okay. I'll make a motion to nominate Elaine Orr as the third member to the JPC.
So moved?
There's a second to this motion, so all those in favor? Aye. Opposed? Not even pleading the fifth. Oral update from the CEO, Mr. Peña.
Thank you, Mr. Chair. Quickly, I just want to start by saying I echo trustee, he used to be a trustee, CIO Palani, and his nice words about Chair Lodge, and I just want to finalize it by saying he had a way of disagreeing with you, but still making you feel good about it. So I appreciate that. Not always, but in many instances, that was the case. So thank you. Now to my update. The employee member applications closed last Friday, November 15. The election will actually be held on Monday, January 6. That is for the position that is going to be vacated by Trustee Lodge. And we're hoping that once the election is held, then the City Council will appoint the new member in time for your January 2020 meeting. I also wanted to let you know the Retirement Stakeholders Solution Working Group had their first meeting last Monday, November 12th, and the group is comprised of about 19 different individuals, which include both chairs of each board and the IC chair from each board. In addition to Prabhu and I, we both made presentations to the group last Monday, and the next meeting is actually December 9th. Now, to that extent, I just wanted to also share with you that the city is requesting further presentations at the meeting on the 9th, and one of them that they're requesting is from Chiron, Bill Hallmark, basically speaking on providing some background on how boards determine amortization schedules and the definition, not the definition, how they arrive to the decision of discount rate, among other things. And so the question was posed, is Bill available or not? And would the boards will be amenable to agreeing Bill to participate and present in that meeting. So I just wanted to open that question to you, board, for direction on what should I be getting back to the city on that request.
Do you have more oral update?
Yes, I do. You want me to go through it?
Yeah, get her done.
Okay. Just wanted to let you know the open enrollment for healthcare started November 1st, and we actually had our healthcare fair at our location on November 6th, and it was well attended. As I promised before, we are working with the communications consultant, and we will be issuing the first edition of the new revamped newsletter by mid-January. So you will see it on your meeting in January, plus all members will receive the new newsletter that will be issued on a quarterly basis. We also, I wanted to share with you some changes on staff. We had a new office specialist started in October, Patricia Oleg and Julie He, our new financial analyst, started with the investment group in October, and Cecilia Cheng, our new benefit analyst, started this past Monday. Lastly, I wanted to make you aware that the last RFP for legal services was issued June 2011. All contracts will expire on June 30th, 2020, and that means your general counsel, fiduciary counsel, tax counsel, investment legal advice, and disability counsel. And so we are going to be issuing a new RFP. The goal is to complete the RFP by next month. We're hoping to post it in January and proposals hopefully due by the end of February. The goal is to have presentations, if anything, or decision-making or selections on those IU meetings on April 2020, so that we can then work on contract review and completion in time for the due date of June 30th, 2020. That concludes my update, Mr. Chair. I'm happy to answer any questions.
Mr. Peña,
Yes.
you said we have 4 different legal roles, jobs.
Yes, we do.
So who is general counsel?
Reed Smith is general counsel and fiduciary counsel. Reed Smith with Harvey. Hanson Bridget is investment legal advice. Ice Miller is tax advice. And Saltzman and Johnson is disability and domestic relations orders advice.
I'm still missing one. Mr. Liederman, Mr. Ricada, tax
Ice
and,
Miller. Ice Miller,
And
who
investment.
you haven't met with
And-
much, and Hanson Bridget, who also does some investment stuff who you don't meet with much.
okay.
They're basically mostly advising staff on how to complete their contracts.
Yes,
Thank you.
you're welcome.
More questions on stuff from Mr. Peña? I do have a comment about the Chiron piece, so please.
What is the process and timing for the selection of a new chair?
December.
It's going to come to you the next meeting.
It won't be me.
Basically, you're just going to propose and select a chair among yourself.
A chair and vice
December
chair.
meeting.
You'll have a chair and vice chair
And the vice chair
election
as
in
well.
December.
Yes.
So then they're usually they are chair and vice chair for the calendar year. So they span, so all of 2020. That's been I think it's what our policy says, that our chair positions are seated for the calendar year generally.
Last time you selected a chair, he remained for 10 years as the chair of the board.
Well, no. Every year I've offered for someone else to take this job, and every year no one said yes, so.
Okay,
So
I would just,
let's be accurate. Okay.
well, I was accurate. Just no detail.
Yeah. So on the Chiron piece about supporting.
Yes, Mr.
So
Chair.
the challenge here is, we don't have a formal request in any kind of manner. So typically, we've done this, is we've supported some activities as it relates to communication to the city around education and information about board activities that have actually transpired, as opposed to anything prospective and hypothetical. If the request is for Chiron to present what the board has done around discount rates and how those things have been set, generally, if that's the request, it seems in line with what we've done. But if it's, what can you do, how can we do, can you make your fancy model do fancy things for us while we ask hypothetical questions, that seems outside of the purview and might need to get kind of narrowed in scope and have real defined, and especially who's paying for those services, because we like Chiron, but they also don't do stuff for free.
That's a good question, Mr. Chair. I don't know if Ms. Cordova, who is sitting here this morning for Sheriff Parkman, can comment on it. I am not clear. I would guess it's a combination of, in other words, I would guess that what the committee is looking is to understand the process by which you select how you arrive to amortization schedules and the discount rate. And I suspect that to that extent, Chiron may present some of the work that has been done by the board, but to be honest, I'm speculating, and I will just defer to the city This time will be Elsa, although in her defense, I'm not even sure that she's really clear as that as well, as she's probably smiling and thinking, why are you asking me, Roberto? So I was wondering if you can provide any explanation or information on that request. And while you do that, I'm going to read the actual request that I received by email. We're hoping that the board actuary, Chiron, will be able to present on the amortization schedules and the discount rate, since they have presented on those items to the boards before. That's all I
So
got.
if it's recycling prior, and prior presentations, is that?
I'm guessing, but my take on that is that they don't necessarily need to revisit the decisions by the board as much as they need to understand the process by which the board makes those decisions. That would be my guess, but I don't really know.
I believe that that's in alignment with the request that came from Cheryl Parkman. I believe the intention is to understand how the discount rate is determined and get some of that background. I don't believe it's to go into the hypothetical, or,
Yeah, the
go through
Nancy
different
part,
scenarios. And I don't think that there would be any concern with further defining what exactly is going to be discussed at the meeting and having clarification around that, if the board's okay with
so
this
again, my
request.
recommendation would be, if you guys want to act on that and say, not act, if you want to direct staff to coordinate this, we should have very clear parameters around what we allow and direct, and check with council to make sure that we're in line with our contracts and not causing any conflict of interest, or getting things out of wind. But Mr. Lehman, you wanted to say something? It's on all the time. Or you killed it.
This one's not.
Grab the other one.
Maybe there's a reason for that.
That's good, I'd like to have that all the time. I heard two different things. I heard from the email request, it was for Chiron to explain amortization schedules and discount rates. I heard Mr. Pena say how the board decides amortization decisions and discount rates. At some point, someone's going to have to, if they want Chiron to show up and present something, they need to tell Chiron what they want to present. And I think it would be appropriate, once Chiron gets that request, if you'd kindly share it with staff, the chair, and myself, then, we can look at it and say what's appropriate for the plan's actuary to state to a group like this, and what's probably outside the scope of what they should be doing. But I can't tell now, because I don't know what the ask is, and Chiron doesn't know what the ask is yet, so maybe we should just wait and see what the ask is.
The question is, do you want to direct staff to be able to do this prior to your next board meeting, which they'll have their next governance meeting, or their, whatever the
Working group.
the working group meeting will happen before your next board meeting.
Correct.
Do you want to direct staff to deal with that, or do you want to say, I'm sorry, we don't have information, we can't direct Chiron to support that?
The next meeting is on December 9th.
Yes. And I do want
It's a
to
fun timing opportunity.
correct myself. I forgot that council may correct me. When I said how the board, I meant the process by which any board will be determining those two things. Not about how this particular board did it, but what is the process like on an actual basis to determine amortization schedule and discount rate, which is more sort of on the line of what the email refers to and what Ms. Cordova indicated. So I wasn't referring to this particular board per se, but thank you for your clarification.
But I suppose, how it happens is the actuary presents options and choices, and the board deliberates.
Mhm.
So I suppose there's nothing wrong with Chiron putting in their last go-round, that was a public document, and say, this is how we bring our recommendations to the board, as an example, if that helps understand the process.
I will
That's
be
no
happy to
problem.
take direction.
There's also another issue about any cost incurred, because if it goes beyond what they've already done, then Chiron is going to be wanting to get paid for their service, and I'm not hearing an offer to pay from the requester.
Yes, that's an issue that I will certainly need direction on. I will say that what I will do is, once we have a clear understanding, first of all, I did make clear to the city that that will be an issue that need to be addressed, because I'm not able to spend dollars on the fund in this particular request without the authorization of the board. So if you may, what I will like to receive is direction from you, board, to work with the city and council on this request, to be very clear what the request of.
And your vice chair.
And the vice chair, thank you. To understand exactly what the specific request is, so that we can then have a conversation internally to determine whether the funds, who's going to bear the cost of this work, whether it could be the board, depending on the work, or it's actually to be paid by the city on the request.
And, Mr. Ludeman, is this something we can do, or we would just provide direction today?
Yeah.
No authority,
It's not an
per se.
agendized matter, so
Right.
at most you could provide direction to staff to do something.
I'm comfortable providing direction to staff, Mr. Pena, to have that more follow-up discussion with the manager's office and with Chiron to determine, and with council, to determine if the request is appropriate, and the content is not doesn't create any conflicts between what Chiron does for the board versus what might be asked from the city, and then proceeding as appropriate from that point.
Anybody disagree with that direction? No. Awesome. Thanks.
Thank you.
Ms. Groen, oral update from the city council liaison to the board. We have the chief of staff for the council member here to provide some updates.
Hi, good afternoon. My name's Mary Ann Groen, and I'm Chief of Staff for Councilmember Deb Davis. She's at a Caltrain board retreat today, so I'm here on her behalf. Just one update, there was quite a lively item, 3.3, on our last council agenda on Tuesday. It was the exploration of a potential real property transfer tax measure to be put on the ballot in March. The direction was that the city attorney and city manager were to explore putting that on the measure, on the ballot in March. It was an 8-2 vote to go ahead and start the work on that. The transfer tax would be on all recorded real estate, which is a little different than some other cities will do it on all real estate transfers. This would bring in about $70 million annually to the general fund. It is a general fund tax, or a general tax. It's not a special tax. So it's a simple majority to pass, unlike a 2/3 vote needed for a special tax. There were multiple council memos already dividing up the funds and how it could be spent. Yeah. So because it is a general tax, it goes into the general fund and then it gets decided on. It can be decided on by this council at this point, and it can be decided on future councils as the tax continues. So that's about it. If you have questions on it, there is a wonderful staff memo, but they will be coming back December 3rd to the council.
And this isn't a bond measure as was proposed on some of the other things in previous
Correct.
years where
This
we
is a
needed to
tax.
provide.
This is a general tax.
We needed to provide some support for the information that goes on those bond measures. This is not something like that. That's the differentiation.
They did go out polling, and the polling question that was tested was to fund general San Jose City services like providing for affordable housing for seniors. So there was some suggestions, but that's not necessarily what it could be spent on. And it's all property transfers above $2 million, and there are increments. Councilmember Foley had a question and a concern that as we as our real estate keeps increasing, that the median price of a house could go up to $2 million, and it could affect a lot more people, so there was a concern. And they may build something into the measure that allows for that increase in that.
Okay. Any questions for Ms. Crum?
Just a quick one. Is the tax to be paid by the buyer or seller or both?
You know, I'm not sure.
I'll check the memo or find.
Yeah,
out
the
whatever.
memo may have it. You may have to call our city attorney's office too to see how that transfer tax. It's all recorded transfers.
Thanks, appreciate it.
Thank you.
Okay, move on to 6C. This is discussion action on the demographic assumptions and methods for the June 30, 2019 pension actuarial evaluation as presented, to be presented by Chiron. And if you'd all grab an extra microphone maybe so make sure that everybody can get heard.
I just closed my laptop here. Let's see if I can bring it up.
Nice picture, Bill.
All right, there we go. Sorry about that. Thank you. Good afternoon. We are here to present the preliminary evaluation results from the June 30th, 2019 valuation, and to go through the demographic experience study and the expected costs of recommended changes from that study. In October, you'll recall, we discussed economic assumptions. Today, we're hitting the demographic assumptions. We only review the demographic assumptions every 4 or 5 years. It's been 4 years since we've done it. So we have more detailed information in here to walk you through what the analysis is. We are going to try and move through the presentation quickly and hit the highlights, but please stop us as we go along if you want any additional information on a slide. At the end, we're hoping we can get a final board decision on the assumptions, and that will enable us to come back at the December board meeting with the final pension valuation. I should mention, it's not on this slide, but at the December board meeting, we will also be bringing the assumptions for the OPEB valuation, the retiree health valuation. Just quickly, at the October meeting, we reduced the wage inflation from 3.25% to 3%, and our amortization payment increases from 3% to 2.75%. Everything else stayed the same. So with that, Stephen's going to talk about the preliminary valuation results.
Okay, I guess I'll use this mic.
You can do both, make it stereo.
Actually, this one will probably be better. So moving on to slide 5. Just want to note that these preliminary evaluation results are preliminary, you know, and we have not finished our internal review processes in peer review. So the final results may differ. We don't expect them to, but they may. And we're including these, initially, we're showing the results before any assumption changes. And this is intended to provide the board with a sense of the evaluation results. So moving on to slide 6, you can see on the left side, we're comparing the contributions, both the city and member rates for fiscal year end 2020 and fiscal year end 2021. So that the baseline is those are the new results on the right. You can see that the results are pretty stable, 7.8% both years for the member contributions, 58.2% for the city rate, changes to 58.1%, and the total contribution is a bit more over the Treadwater rate in fiscal year end 2021. On the right-hand side, we show the funded status, again, pretty stable, 53% on both, and the liabilities have increased a bit, but so have the assets. Moving on to slide 7. Here we show a breakdown of by tier. And you can see, again, that not a lot of movement. The liability in total went up 2.5%. Actuarial value of assets up 2.3%. The funded ratio pretty stable on both an actuarial value and a market value basis. There was a gain on liabilities, being about 23 million less than expected, and the return on the market value of assets was 3.6%, so that is a loss versus the assumption. And on the actuarial value of assets, that's a bit lower at 2.8%, and that's because of the smoothing in of prior losses. Overall, the UAL increased because the loss on assets was larger than the gain on liabilities. So 53 million increase on a market value basis and a 40 million increase on an actuarial value of assets basis. So on slide 8, we compare where we thought things would be last year versus where they are now under the preliminary results. And the bottom line is things look pretty similar. The Tier 1 UAL payment is increased a little less than expected, but if you look at the bottom, the 59.2% aggregate rate came in at 58.1 under these preliminary assumptions, and that's because of the growth in payroll, a bit more than expected.
Okay, so the basic results are pretty stable. And then we look at the assumptions. The end result of this is we made a bunch of tweaks to all of these assumptions. I think the most significant changes are the mortality change, the retirement rate change, and then we're changing the structure of administrative expenses. So we'll go through these and hit the highlights, but in the end, some cause costs to go up, some cause costs to go down, some shift a little bit from Tier 2 to Tier 1, but in the end, there's not a huge movement of costs.
The first assumption that we looked at was the merit salary scale. Now, this is in addition to the wage inflation assumption. So typically, this is based on years of service, and you typically see your increases, decreases as someone's service increases. What we noticed, if you look at the graphs, and you're going to see this type of graph for all the different assumptions, is you've got your blue line, which is what your actual experience was. The red line is the current assumption, and the green line is what we're proposing to change the assumption to. So as you can see, the actual experience for the merit increases was lower than expected for the earlier years of service and later on. So what we're proposing is to lower the assumption for less than 2 years of service and slightly lower it at the very end after 13 years. And in between, we're proposing that you increase the assumption, and that's just so that the proposed assumption now it's partially reflecting your actual experience. The next assumption was administrative expenses. So the current assumption is that it's 1% of payroll, and this assumption was set in place before Tier 2 even existed. So what happens is when you have the 1% of payroll, your Tier 1 members, their portion of that is 3/11, and Tier 2 members is 50%. But what we have now with Tier 1 being a closed thing and their payroll decreasing, you're seeing the proportion shift more to Tier 2. So as Tier 1, everyone retires, you're going to eventually see Tier 2 paying the entire administrative expense. So what we're proposing is that you change the assumption so that it's based on the head count, and that will include actives and inactives for each tier. So if we look at the past the last few years of your actual administrative expenses, it works out to be about $500 per participant. So what we're proposing is that you set it at that, and we assume that it's going to increase at 3% a year.
So before we get into the analysis of the other assumptions, we just wanted to make sure you understood the statistics that we're using, the key statistics we're using to set these assumptions, because these terms will come up over and over. The first one is the actual to expected ratio. It's the actual number of retirements, number of terminations, number of deaths, compared to what we expected based on either the current assumption or what we are proposing to change it to. Ideally, it's 100%, but it may not be. And so we try and move it towards 100% from wherever it is. That helps us set the level of the assumption, but it doesn't necessarily reflect the pattern. So for example, we could assume that everyone under 60, 50% of them retire, and only 10% of people over 60 retire, and we could exactly hit the right number of retirements, but we would have predicted the wrong people retiring. We would have predicted the young people retiring instead of the old people retiring. So we use a statistic called R squared that measures the variation in the experience captured by the assumption. So this is like, does your pattern fit what the experience is? And ideally, that also goes to 100%. And so when we change the assumption, we try and get it to move towards 100%. The third statistic we look at is a 90% confidence interval. It's the range around the observed experience in which we think the true rate falls with 90% confidence. And so let me just illustrate that.
Can I stop you there? 'Cause
Yeah.
I kind of missed the connection. The actual to expected ratio, could you just redefine that for me fully? I don't think I'm.
So that's, for example, if we observed 5 retirements at a certain age, but under the assumptions, we only assumed 4, that actual to expected ratio would be 5 to 4.
Okay.
So it'd be 125%. So the confidence intervals, the idea here is it helps you to see where you have a lot of experience and can be confident that what we observed is the real rate versus just random fluctuations. And so the idea is, the more times you flip a coin, the closer you're going to get to a 50% heads, 50% tails distribution. Here, the example is, what if we had something where we observed a rate of 10%? If that was 1 out of 10, or 10 out of 100, or 100 out of 1,000, the range of variability around that observed 10% that we think the true rate is gets smaller and smaller. And so we create these gray boxes that are the confidence intervals, and we try and make sure that the assumption falls within the confidence interval. But suppose in this example that our assumption was 20% and we observed the 10. If we only had 10 exposures, that'd be in that far left box. That would still be within the confidence interval. We wouldn't necessarily be suggesting a change. But if we had 100 or 1,000 exposures, that's outside of that confidence interval, and so we'd say the evidence is that we need to change that assumption. So that's the general approach that we're taking in looking at these assumptions.
So the next assumption we're going to look at is the retirement rates. For Tier 2, there isn't enough experience yet to analyze that, so we're not proposing any changes to that. But for Tier 1, we definitely have enough experience to analyze that. So first of all, when we look at the retirement rates, we look at 3 different service buckets, and then we look at it by age within the service bucket. So in the chart above, you can see the 3 service groups that we look at. We group everyone in those different groups. And you can see AE ratio, our current assumption on the left, and then the proposed assumption is what we're proposing to change the assumptions to. So you can see in all 3 cases, all 3 buckets, the top one we're actually getting to 100%, and the other 2 we're getting much closer to 100%. Same for the R squared. Our proposed assumptions we're seeing a much better fit than the current assumptions. So if we look at the graphs for each of the 3 groups, you can see for the groups of 30 or more years of service, we're proposing that you drop the retirement rates for ages 56 and higher. You can see it better fits into the confidence intervals and better fits the current experience that we're seeing. For the next 2 groups, obviously, we had more experience in that, so you can see that your confidence intervals are far more, much smaller than the 30 and above. So for people that have less than 15 years of service, that's a 0 to 14 years, the top graph, you can see for some ages, we're proposing that you lower the rates. Sometimes we're proposing that you increase them. And you can see, once again, now falls within the confidence intervals and better fits the actual experience. For the people that have 15 to 30 years of service, we're proposing that you drop the rates for actually all ages.
Let me just add a comment here that coming out of the Great Recession, we saw a significant increase in retirement rates, and we partially reflected those in our assumptions. But now we're seeing the rates drop back closer to where they were before the recession, and so that's what these changes are reflecting, is kind of a return to what is a more or has been a more normal pattern.
Okay, for termination rates, when we look at these different rates, obviously we look at them by age and by service. So in the past, the termination rates were based on age and service. When we do these experience studies, we look and see if it's appropriate to do it on both, or just on age, or just on service. So we're looking at this one, we're proposing that you change it to just a service-based table. So we felt that the age, it didn't affect it as much as service did. So you can see, once again, the AE ratio, there's not much change in that one, but the R squared is slightly more improved, so you're closer to 100%. And if you look at the graph below, this is for all ages, and it's just by service. So you'd have one set of assumptions, and we in some cases, we're proposing you drop it, and in some cases, we're proposing you increase it. The refund rates, these are for people that terminate, that are vested and are entitled to a deferred vested benefit in the future. We look at it and we say what percentage of them elect to take a full refund and what percentage elect to take a deferred benefit. So the refund rates are for the ones that are going to take a full refund of their contributions. So again, our AE ratios for the 3 different age buckets. So in the past, actually, it was only age-based, but now we're saying we are recommending that it's based on age and service. So we've got 3 different age buckets, and you can see the AE ratio gets much closer to 100, and the same with your R squared. And these tables pretty much showing the same thing. We're proposing increases in some, decreases in some. For the ages 45 and older, you can see that the current assumption was very, very low, but we're proposing that you do have an increased assumption for that. For the disability rates, this one's just a little trickier in that you really don't have, you typically don't see enough experience in this to create assumptions that are unique to your individual plan. So there were only 52 disabilities over the observed period, and it's quite a few years. So what we're proposing is that you use a standardized table, and the CalPERS table for ordinary disabilities, that fit your experience the best. And what we did is we took it is split by gender, so we made a unisex table out of that using your ratio of male to female active participants. So it'd be 55% male, a 45 female blend of that table. And then we apply an adjustment factor to get a better fit. So you can see your AE ratio, it is decreased, and your R squared, it's not as high as you'd want it to be, but once again, disabilities are very hard to come up with a unique table, so it is best to use the standard tables.
So I'm going to talk about mortality and start with the mortality improvement. And we've had a long history of mortality improvement, and there's been a fair amount of discussion about it with pension plans. And since I think everyone on the board here is new, except for Matt, since we last talked about this, I thought I'd at least touch on this history. So just so you can read this graph, this goes through history. This is looking in 1900, and you start at an assumption of 100,000 people being born, and the graph shows how many are still alive at various ages. So you can see that there's a significant drop in the first 5 years of life due to mortality. And then we follow this kind of nice curve that as we roll forward and look, now I'm looking at 1910 and 1920, 1930, 1940, there's significant improvements in mortality, but most of that, or a substantial amount of it, is in the first 5 years of life. The overall shape of the curve hasn't really changed, and there aren't a whole lot of people living beyond 95. As we go forward from there, we start seeing growth or improvements in mortality at some of the older ages. It doesn't push people to be living to be 120, but a lot more people are living to be 80 and 90 as we go forward. And the studies look at it, you can see where the impact of Medicare coming in, smoking cessation, statins, and those various impacts. Those are the types of improvement in mortality that really affect pension plans, because we start our payments at retirement, and so the more people who are living to age 90 or 95, the more expensive it is. And so, So there has been this long history of improvement. We expect that level, we expect improvements in the future. There's a lot of speculation about what that level of improvement would be. We've adopted here a practice of using the most recent mortality improvement scale published by the Society of Actuaries. And they publish one every year in October. So the most recent scale just came out a few weeks ago. And so we're suggesting that we just continue doing that. They have a model they use that stays fairly standard, and they update it each year with new data from the Social Security Administration and the Center for Disease Control. And so we've just been adopting that model. Now, we apply that projection of improvement to a base mortality table and that projection is a generational projection on that base table. And what that means is effectively we have a different mortality table for each year of birth. So that the chance of a 70-year-old today dying is going to be much higher than a 70-year-old in 20 years. And so by doing this, we've built in that improvement by year and reflected it in the population. This year, the society did their first ever study of mortality on public plan data. So they gathered data from large public plans across the country and collected mortality information from 2008 through 2013. They had 46 million life years and 580,000 deaths in the study, and looked at the key variables that affected mortality. And we know sex makes a difference. Women live longer than men, and we've always had, well, maybe not always, but recently we've had different tables by member status. So we obviously have different tables for disabled retirees and retirees, but we also use different tables for retirees and active employees. One of the things that was a little bit surprising was they found a very significant factor based on job category and split it between teachers, public safety, and general employees. Teachers by far live the longest. And then the other piece is that income and benefit level is a very significant predictor of longevity. So what we're suggesting this year, we had been using CalPERS tables as a basis, but we're suggesting switching the retiree and employee tables to be based on the total general member tables. They have above median and below median income tables, but we found the best fit just using the total tables. For disability, the CalPERS disability tables still had a pretty good fit for us. And then we adjust the tables for federated experience. Now, the issue is that to fully adjust the tables, we would need 1,000 deaths to have credible experience to fully adjust. We only had, we only went back 10 years, Matt. I know when you were saying you went 12 years, you had over 1,000 deaths have come through here. But we had 923 deaths in our experience study. But that's spread across all the different tables. So each one is just partially adjusted for your experience. So we start with that published table, and then we make an adjustment towards your experience. We also do our analysis benefit weighted. Because income is such a large predictor of mortality, what we're concerned about as a pension plan is not the number of people who die, but when the benefits die, when you stop paying the benefits. And so it's the retiree analysis is weighted by benefits, and the active employee analysis is weighted by salary. So this shows the results, what we end up doing to the table. So for example, on the male service retiree, we took the table. We had 367 deaths based on that level of credibility and the differences with your experience. We multiplied the table by 0.995, which means it was already a very good fit for your experience. And after doing that, the actual to expected ratio on the benefits weighted basis was 100%. So you can see the summary of all the tables there. I'm not going to go through them all. I will note that the active employees, we get a lot of variation around that because there are so few deaths. And so those actual to expected ratios are not as close to 100% as we might want, but there's not really enough evidence to move the table one way or the other. So any questions on the assumptions or the analysis before we talk about the cost impact?
I have a few questions. Regarding, one is more clarification regarding administrative expense. They changed assumption to 500 per person. I just want to make sure that's for all members in the system, including retirees, right?
Yes.
Okay.
And that's really the point of that change, because we were getting to the point where Tier 2 payroll is greater than Tier 1 payroll, and so Tier 2 members were being charged more of the administrative expense of the system, or assumed to be charged. They weren't actually in the way the system allocates the costs, but they were assumed to be charged more than half of the administrative costs of the whole system. And it seemed more appropriate that the administrative costs reflect the total membership, including retirees.
Okay. So by changing that from a 1% of payroll to $500 per person, so initially, we're not going to see much of a change from last study to this year for dollar amount, are we?
It goes up a bit, but it goes down for Tier 2 and up for Tier 1.
Well, I'm talking about the total dollar amount.
The total dollar amount goes up a bit, but
A bit, okay.
it's more, the shift is more significant than the total change.
Okay. There's another comment I want to make is, by reading your full report, you mentioned that the termination rates are not studied by tiers. So I just wonder, I don't really know the statistical significance for termination by peers, but I think in the future, it might be helpful to study that. My reasoning is rather simple because the benefit structure for Tier 2 members, for lack of a better term, is not as attractive as Tier 1 members. So I figure the termination rates for Tier 2 member might be quite a bit different from Tier 1 members. That's just my thought. So I'm not saying you should do this for this study, but next experience study, we might need to take that into consideration, especially when we have a more and more Tier 2 members.
Yeah, so it gets taken into account a bit implicitly because it's by service. And so we don't have any Tier 1 members who have only 3 years of service, and we don't have any Tier 2 members who have 20 years of service. And so there's a natural split that happens there anyway. But the issue that you're raising that we have to keep in the back of our mind is, even though we don't have Tier 2 members with 20 years of service, their termination rates may not be the same as the Tier 1 members with 20 years of service that we can study. And so we do have to keep that in mind and monitor it. At this point, looking at the earlier years of service, we haven't noticed a real difference between the two. And so it's hard to speculate about what that difference would be in the future.
More questions?
No.
Great. Just to note, at 1 o'clock, I need to call a recess so they can do some audio-visual changeover. I think it's around 1 o'clock I need to do that. It's a technical thing we need to do,
We can
so.
wrap this up quickly.
Well, again, we'll likely go blow past 1 o'clock. I'm not worried about that. It's just to make sure that if I say timeout, there's a reason we have to do some stuff.
If I may, Mr. Chairman, just one quick question. I think it's on slide 11. Yeah. This shows merit assumption increases through 15 years of service. What happens after 15 years of service?
It
What's your
stays constant.
It stays constant?
So the number at 15 is really 15 plus. 15 or more years of
So
service.
Well, that's at zero, so is.
It's close
maybe
to zero, it's not quite zero.
So you don't expect for, if somebody works 30 years, that over the last 15 years of their service, they're not going to get any merit increases?
They will get the across-the-board increases, and then there is a tiny piece that's for promotions.
Yeah, so this is over and
Wow.
above the wage inflation.
That's rather striking, and that bears out in the experience study.
Yeah, and that's, you know, it's typical that there would just be a tiny piece left that, because the way the steps work, they've gone past the end of their steps for almost all classifications. I think after like 10 years of service, they're beyond all the step increases. And so the only increases above the across-the-board increases are for promotions. And so it's the number of promotions divided by everyone who didn't get promoted. Kind of.
Stunning.
It's got a fun math, huh? Math runs the world, right, guys?
Yeah, I guess so. Just by the time you work 15, 20 years, you are at the highest level of the management, and so there's no move for promotion anymore. The city managers will be there forever until he retires. Right?
What's the longevity part of that then? Longevity ends at 15 years? That's really what happens?
What do you mean, the longevity?
You don't get a longevity bonus or something like that?
No.
Beyond
No,
that?
we don't.
No, you
Not even
don't.
a 5, 10, or 15, or 20, no.
Wow.
There used to be something where you get a $500 check if you've been in your classification for 10 years and hadn't entered a top step and haven't gotten a raise.
That's
That-
all I.
Now, they have merit increase opportunities that are, but you have to be an outstanding performer as well, and sometimes they are, and sometimes they aren't.
I think if I read this study
Right.
correctly, it looks like the merit increase, that the standard merit increase called out by the cities may have been taken into the consideration of the wage inflation. I think what they talk about the merit increase is more like a promotion. And I would say from empirical evidence, it is true. People earlier in their career tend to have a bigger promotion than people in the later career. Theoretically, when you are later in your career, you probably have to advance to the level that you're going to hold. And then the further experience you are in your career, it's harder to get a promotion. So it's harder to go from the deputy manager to the deputy director to the director. It's even harder from the director to be the city manager.
Yeah, so the positions actually, as you go up, are more limited, right? So
Yeah,
there's only
yeah.
one city manager,
Yes.
so only one person can be promoted to city manager.
Yeah.
There's only so many director slots, so as you continue working on each years of service, the chances of you getting promoted are lower.
Yeah,
So.
yeah, the
And-
probability is lower.
And you're correct, in counties, they do have the longevity pays, not in all of them, but in many, but that's not the case in here.
I find it surprising too. Jackie, what was the methodology behind the current, what is the methodology behind the current estimate? And how again is that changed to the proposed? Are they both based on past actual?
So the blue line is the actual experience that we
Right.
saw. And the current is what we assumed was going to happen.
Based
you-
on,
That's the current assumption, that's based on the last experience study that we did. So the current assumption is based on the experience from the last experience study. So what we do is now, the actual experience that we're showing here, that blue line, that's from this experience study, so it's more recent. So what we can see is it's differing from the current assumption, and that's why we partially adjust the assumption so that it more fits the most recent actual experience.
okay,
Yeah.
thank you.
So we're gonna keep charging ahead until I think 1:10, but I'll get somebody shouting at me, telling me to do something else, so we're at 27 is where we stopped.
Okay. A lot of slides there. Okay, so on slide 27, we pull this all together and show the impact on the rate. So slide 27, we're just looking at the member rates. And you can see, if you look at the top, before assumptions, tier 1, 7.05, tier 2, 8.36. If you go all the way down to the bottom, after assumptions, 7.16, Tier 1, 7.96 Tier 2. So not a, not a huge impact here. Partly that means the assumptions were already doing a good job. But I would like to, point out a couple of the items. The administrative expense, so using the per head methodology does increase that for Tier 1, and it takes some expense away from Tier 2, so you can see the movement there. But that's really the largest impact.
Yeah.
And then, so moving on to 28, we show the impact on city contributions. So this is, again, not a huge impact, although the mortality on Tier 1 has a significant impact. Again, the expense is adding to Tier 1 and decreasing some of the Tier 2 expense. Net change of 3.6 million and about 1 million on Tier 2 decrease.
I should note that, and I think this is best illustrated with the retirement rates line. We only changed Tier 1 retirement rates, but the Tier 2 number went down. The reason the Tier 2 number went down is we assume that when a Tier 1 member retires, they're replaced by Tier 2. Well, if they don't retire, then Tier 2 doesn't have to pay their normal costs. So the Tier 2 went down because you still have a Tier 1 employee and you don't have a Tier 2 employee. So there's some interesting back and forth.
Yeah,
between
there's
the two.
some interplay with keeping the
Is that what you call
payrolls.
actuarial science?
Yeah, there's a bit of interplay with keeping the payroll stable between in total, yeah.
Yeah.
Okay.
On the admin expenses, that creates a funding pool for administrative expenses. And is that the same pool, Mr. Peña, from which capital expenses come? So like, we did the pension system upgrade, that was like a $10 million.
That expense is not part of the administrative expense.
We budget that separately
Yes.
for another process?
That's exactly right.
Okay.
There. You want to talk funded status?
Oh, okay. So slide 29 is very, very similar to one of the early slides, but now we're showing the results, including the proposed changes. Again, not a lot of movement here. The actuarial liability does reduce about 2.9 million, and the funded ratio increases a little bit. Basically remains pretty similar. Again, not a lot of movement versus the earlier slide.
So I
Sure,
think,
same material.
just to cut to the chase, I think in aggregate, what's happening here is we expected the costs to go up to 59%. Before the changes, they had dropped back to 58%. With the changes, they're back up to 59%. And the dollar amount is a little over 2 million more than what we had expected originally. So there is a slight increase for making the assumption changes, but it ends up being the same percent of payroll that we were expecting. This just shows the steps. I'm not even going to pause here because I already talked about it, and so we're just looking.
Going back on 31 there, as we're going through, I also, as you use the adjective minimal or tweaking of the numbers, but the treadwater number seems to be significant. It's all relative, right? But the changes in the demographics didn't seem to be that big, yet the change in the treadwater.
The treadwater went down a bit. Let's see, so the liability went down by a couple million, so the interest on it went down.
It's less.
The normal cost also went down. And so that, is that right?
Yeah, so that Yes,
But
the
there-
trade ward is the normal cost rate plus the interest on the UAL.
Right.
So that by both of those components decreasing, that's why you're seeing like a compounded decrease on the trade water rate.
But yeah, all the numbers are just marginally, but yeah, you're seeing the tread water go down a little bit more. It also may appear to be going down more than it actually is because the yellow bar is going up.
Optical illusion.
Yeah.
True.
Or you're paying less interest, more principal. Can I ask a question
That's
on
good.
funded status? In this in this chart, you're showing the aggregate funded status as a 53%. In a slide, couple slides before, no, not the cost, what's that? In a table, slide 29, you have a funded ratio at 50%. How do I reconcile those two numbers?
Because one is the actuarial value of assets funded ratio, and one's the market value. So in this table, in the middle of the table there, it shows the 53%.
Oh, okay.
The
And
city
then-
pays contributions based on the actual value of assets.
So the actuarial value is that smoothed value, so we're smoothing the investment gains over 5 years. And right now, it's about 100 million larger than the market value.
Okay, got it.
More decisions.
I make a motion to adopt the demographic assumptions as described by Chiron.
Is there a second?
Second?
Okay, comments, questions, dialogue, interrogative? All those in favor?
Aye.
Aye, opposed? None? Thank you.
Thank you.
Thank you.
Thank you.
Okay, I've got 5 minutes till we have to take a break for a few minutes, just for them to do a technical changeover. We're not in the room, so it'll just be a few minutes. So this is item 6D. This is a discussion and action on the compensation and benefits for the Office of Retirement Services Chief Executive Officer and Chief Investment Officer. I'm going to make a recommendation that we defer this till next month because the CIO's performance appraisal has not been delivered to him yet. And so that discussion hasn't happened, so you can keep these things paired up and you can deal with those things next month. And that's really the only reason. So my recommendation is to defer this. If nobody cares, that's okay. It'll be taken up next month and agendized. I'd already talked to Mr. Castellano about that to make sure. Okay? So deferring 6D. So it'll be carried over to next month. All right, 4 minutes. From the investment committee, we had not met last month. And there's 2 minutes that were noted and filed to receive and file there from Aug 27. The governance committee, 7-2, that had not, they are meeting,
Next meeting is next December.
the next meeting is in December. Okay, so that's kind of oral update then. Audit committee, you met last month. Let's get through a couple of these items before I think we have to discuss a couple of them. Oral update from the audit committee. Who's oral updating that one?
I don't think that you have a chair.
So you
I
can-
mean,
you can give an update if you
Castellano,
have one.
yeah, so.
Or all the items here to discuss.
That's right. Well, there are not to discuss, Mr. Chair. So items B, C, and D are just updates. And there were presentations made to the audit committee, but I'm happy to address any particular questions that the board may have on those memos. The 2 items is also G and H are reports that were made to the audit committee, and I'm happy to address any questions on those 2 internal audits, which, by the way, were the first 2 internal audits prepared by the senior auditor. The 2 items that we need action from your board are E and F, E being the CAFR, which is the Comprehensive Annual Financial Report for 2018, 2019, and then F, which is actually the report on the findings from the Grant Thornton as the external auditors, which is the internal control over financial reporting and required communications.
That's a great update. So items B, C, D, and G and H are going to be received and filed. And we are going to wait on item E and F for a minute, if everybody's okay with that. We'll look at the joint personnel. So I'm going to pause on items 7.3 E and F, until after we have our brief recess. Item 7.4, the Joint Personnel Committee did not meet since last time, so that's A and B. There's a receive and file for the minutes from September. You have some education and training for the Cortex and Calipers. Any future agenda items? I know we have, I'm not adjourning, relax. And I'll hold on the public or retiree comments in a moment. And so I'll call a recess until we can get the technical switch over, and at that time, we'll come back and deal with 7.3 E and F, and then we'll go into closed session on the investment item, and then we'll come back and adjourn. Okay, we're back from recess. We're on 7.3E, discussion and action on the committee's recommendation on the approval of the Federated City Employees Retirement Systems Comprehensive Annual Financial Report for fiscal year 18-19. So we have the CAFR draft in our packet.
You do, Mr. Chair. It's a regular CAFR with some new sections, but I think the bottom line that I want you to get from that is that we did receive an unqualified opinion, which is the highest opinion that could be issued for the report, in the sense that the financial statements are fairly presented on the GAAP requirements. So I'm happy to address any specific questions that you may have. And if you don't have any, I will recommend to you, board, to approve the CAFR, which is actually the motion that was made by the audit committee that will recommend to you, board, approval for the CAFR.
Great. Do we have any comments or a motion even?
I make a motion to accept the CAFR.
Is there a second?
Seconded?
Great. Any comments or questions on the CAFR? All those in favor? Aye.
Aye.
Opposed? Seeing none. 7.3F, discussion and action on the committee's recommendation regarding communication to the board's administration of the City of San Jose Federated City Employees Retirement System for the Grant Thornton system from Grant Thornton, thank you, for the plan's external auditor. We have the independent report, and we also have required communications.
Yeah, so you have two reports. One is as part of their audit, they issue a report, internal control of a financial reporting, for them to be able to provide their opinion on the financial statements. So that report is there before you. And then the second item is the required communications about findings that they have encountered during the audit. And findings are split in three different status. And so the worst of which we did not have any of those findings, but there are two comments that they provided. One of which is regarding IT. That comment from Grant Thornton, it appears in every report every year, because they are related to controls that are beyond our ability to control, in the sense that they actually come from the IT group from the city. So there is not much, in reality, there's nothing we can do to change those controls, because they actually imposed to us by the city IT. The other one that I wanted to mention was a finding that was actually reported 2 years ago. It went away last year, and it came back for this valuation. It had to do with the findings, a particular GAAP requirement. When you look at recording the investment, the assets of the plan, there are three different levels, and they're based on from the most liquid to the less liquid. Which also goes with the most liquid are the ones that have the most immediate ability to provide the market value versus the more liquid. And so there was a discrepancy in some of the levers that we have staff classifying those assets. And the rationale or the reason behind it was investment. That classification is done by the accounting group based on some investment information. In 2018, we have the financial analyst position that was filled, and investment was able to provide that information accurately and timely to accounting. Unfortunately, during the audit this year, As you are probably well aware, we lost the financial analyst from investments. Investment lost the analyst, but the analyst became our senior internal auditor. So he's still in the office, he was just not performing that function. And so basically, the information was not able to be provided to accounting timely and accurately. So there were some findings by Grant Thornton. That is not an issue that we expect that to be remedied soon, and we expect that change to come back for the 2020 year, as we do have a new financial analyst in investment. So all in all, I think the reports indicates that the findings were not material weaknesses. And again, during the presentation, the audit committee made a motion to recommend to you, board, to approve the reports, and I will recommend the same. And I'm happy to address any specific questions that you may have.
Mr. Peña, in what form or do we at all communicate the IT recommendation to the city IT department? How does that happen?
Do you want to take that?
They have those findings as well, the IT.
Oh, on their audit, the city's audit.
Thank you, Barbara.
Any other questions? I'll entertain a motion.
Motion to accept the independent auditor's report.
Seconded?
Comments or questions? All's in favor?
Aye.
Opposed? Great. So we're going to go into closed session. And projections, 15, 20, 30? How long is it? Do we have any public or retiree comments? We're adjourned.